Broadcast is now starting. All attendees are in listen-only mode.
Sir,
I can start. Please use message if you can't.
yes, sir, you can start. First, I will give you introduction.
Yes, please.
Good morning, everyone. Good morning, everyone. Welcome to GST certification course. So, being the first day, hello.
Audible. Go ahead, boss.
Yeah, yes, sir. Yeah, yes, sir. Good morning, everyone. Good morning. We are starting the GST certification course from Hiregange Academy from today. We welcome you all for joining the session. Being the first session, the certification course will be started by CA Madhukar and Hiregange, who is senior partner in Hiregange Associates. He has jointly authored 18 books from 1997 on Central Excise Service Tax Karnataka Act. Further, he has authored 10 books in GST Primer, GST Classification and Exemption, Compendium of Issues, which are available online. He has fostered 100 plus leading professionals in industries and practice, and he has been actively in the field of spreading awareness through articles and workshops. We welcome you, Madhukar sir, for accepting the session, and I request you to.
Thank you, Arjun, and sorry, viewers, for that bit of technological glitch which we had. Yeah, so we will start with the understanding of this course itself. One of the thought processes is that the 100 of you who have joined this course would be very keen to understand how to learn GST and rise from one level to the other. In this course, we are expecting most of you to have a general awareness of the course. Can you go to the next slide, Arjun?
Yes, sir.
So the stage where we expect you to go through would be the understanding the basics as well as the issues, which certainly some part of it will be done in this course. You would also seen the 4 key topics, starting from the constitution and ending up with cost control. In between, a variety of topics which are problematic areas, also in the normal sequence of the place of supply, ITC, etc. The second stage would be deepening the knowledge and solving real-life problems, which are practical issues which have been faced in GST for the last 33 months. Third stage will be to get expertise, and the fourth stage, as my guru Mr. Ravi Shankar always used to say, you can learn much more working than all the reading you do. So those of you who are in industry will learn on your jobs. Consultants, they will learn when they consult clients or do the audits, etc. One of the aspects is that the base would possibly be available already for all the CS. GST has been in the course now from 2016. Though GST came in 2007, we had introduced the course in 2016 itself, and therefore the newer CS would be very much aware of this. The CS of whom have joined CA after 1996 would have seen the old laws, that is the Central Excise Law and the Service Tax Law, which came a little later. We would all those learnings would be tremendously useful, because those are the laws from which GST has been made. It's an amalgam or a khichdi of Central Excise, Service Tax, VAT, and Central Sales Tax, a bit of customs also. So if you know those subjects, then you know a little bit about GST. However, the differences between those subjects and GST would have to be appreciated. We also find now that courses like CMA, CS, postgraduate in BBM, MBA have GST as part of the curriculum because of its importance. Even BCom and MCom, GST is being taught in a limited manner. Some basics are taught. As far as this certificate course is concerned, we would be covering stage 1 and stage 2 partially. Stage 2 will be partial, deepening the knowledge, because you will get a lot of issues. We have ensured that every speaker is going to touch on errors, common errors, as well as they will touch on some of the issues. The next slide, please. Next slide, Arjun.
Yes, sir. Yes, sir. I have changed.
Yeah, yeah. Okay, good. So they say that even in learning there is a particular type of listening we have to do, and in learning also there is a particular method in which you can retain much more than in normal. So one of the aspects is if you could keep your latest GST Act and rules, whether in soft form or in hard form, with you while you are listening to this. Maybe you can make notes if it's a hard copy on that. You can also go through the material which is shared for the topic of the day. Those could be seen, and also that note, that book, if you're printing it out, that book also could be used for noting. I'm sure all tech-savvy people, you know how to even make notes on those. One of the ways in which we can make this very useful and very effective is if you can go through the material for tomorrow to today or in the morning of tomorrow, read headlines on what is going to be there. Then while the class is going on, please make notes and also pose your questions immediately. On the screen, it will come, but the speaker will only give you the answers in the end. But immediately make your questions so that in the end he can answer all your questions. One of the best ways of listening is when somebody else questions. So when they ask any question, don't assume it's not related to you. It could be well related to you, and it could be a very pertinent question, and capture the answer if possible. After this class gets over at 1:30, maybe in the afternoon, spend about 15-20 minutes, half an hour on what you have learned. Just make short notes on what you learned. After a week or after this session is over, after 13 days, you could also go through those notes as well as the recorded videos which will be available to you. Post the lockdown, obviously you are one step above, and you will become from basic level to ready to take on advanced issues level, and therefore your knowledge has deepened. You've got a lot of examples in your mind about how the provision is applicable, what are the finer points of law. All this you have learned, before you could flourish and empower. Can you take the next one? So this is the way you would like to improve your GST learning. Next slide, please. Next slide. I think there is some technological problem. We'll see. Tomorrow we should be able to correct what is going wrong here. Next slide, please. Yeah. To get a deeper understanding, I think you have to be on the top of this, Arjun, so that immediately you change. Every time we are losing 1 or 2 minutes in slide changing only. So the deeper understanding, what is it you require? You got some basics, and in the certificate course also you will get part of this deeper understanding. Other than the certificate course, you could also buy some good basic commentary Go back, please. Go the basic commentary you will have to go to, and again it's taking time. Basic commentary you could look at, and you could have a referencer. You could also, if you're from corporate or a person who wishes to specialize in GST, buy some legal dictionaries like Black's Law Dictionary, Longren. There are many. You could possibly, depending on how much you can afford, you can buy some of the dictionaries. We use Ramnath Iyer. You could also look at the FAQs. There are some FAQs available on the CBIC portal. There are some books also FAQ. We ourselves are working on one which may come in another month or two. The changes in the law need to be kept abreast of, and therefore you could be part of a subscription of any site which gives you the updation along with some comments. Only updation comes what it is, and a lot of time will be spent on it. If you're in a particular industry, see if there are any sectoral books available, online updates and free answering sites. The PMI. They can also give you some idea, though I also find that sometimes the answers are not up to the mark. However, that is a challenge until one expert site does come up. Subscribe for credible online resources for continuous learning. Be a part of specialized WhatsApp group. Many of us are parts of large number of WhatsApp group. Unfortunately, unless it is specialized, you probably are getting incorrect information which is getting into your head. And once something gets set in your head, then it's very difficult to change it. So be careful and don't join all the WhatsApp group which are available. You could also look at attending seminars, online webinars like this, and study circles in GST in your locality or online. And of course, intern or take a job which allows you to learn on the job. Now you have already got a deeper understanding. You want to become an expert. So the best way to become an expert, none of us have been, at least I cannot call myself an expert. I'm still in the deeper knowledge as far as GST is concerned. I could have called myself an expert in central excise and to some extent in service tax. So I'm still learning, but I'm guiding a lot of people. So I'll become an expert very soon in GST also. Allied and relevant laws are very important. You can't just know the GST law. You should know a number of laws. And today you will have also some teaching on the legal maxims and constitution. Please remember, Naveen sir is going to only take you through a basic information which will give you an idea how important it is. Later you might have to refer to some books, etc. Researching is one of the good ways to learn the subject, and writing analytical articles. Since you already have a knowledge, start writing analytical articles, and the questions which come on your article can answer. That would be the next level you can move. Speak about the subject like all of us here. By teaching, we are learning. Join a debate club. In Bangalore, I can tell you there are Bangalore Study Circle is there. There's one Akshara Study Circle. For those of you who are interested in making your presentation better, Toastmasters, etc. There is such a lot of information available on the net. And if you can make a list of the good contributors, then maybe their articles you can read always. And also, whenever you're doing any work in a particular area and trying to understand an area, on Google, you can get in 5 minutes, you can get some of the articles and you can possibly read them in the next half an hour. Note down that which is looks to be correct, confirm it with your books, and then go ahead. You can also answer on the online forums. That also helps you. And from writing articles, graduate to small booklets and then books. It's not a big deal to write a book. That's what we have realized, and that's how we have created more than 20 authors in our office. Teaching students, professionals, industry, even officers can give you much required different views and depth. As far as this course is concerned, we are starting with the Constitution of India, which is the mother of all the laws in India. We look at supply, levy, what what types of supplies are there, composite, mixed, non-composite. We look at classification and exemption and understand that diligence is required in this. A mistake in this can lead you to a lot of difficulty in the future, and also possible margin erosion totally. Importance and value add in the place of supply is important because of the IGST, CGST, your state taxes, your import, your export being impacted with this. The reverse charge mechanism in India has always been a little difficult area. That would be looked at. Job work, anti-profiteering. We would also look at valuation, because valuation in GST is not merely based on your invoice. Unless the invoice represents the real value, and there is no additional consideration, or it's not with related party, that would be questioned. The discounts, when they are deductible with GST and when not, time of supply, payment issues. ITC, of course, is a huge number of problems in ITC, and the EOU, SEZ have some special provisions which in fact are required to be understood. We are also looking at the procedural aspects, because GST is quite procedural. The registration part, the records, returns especially, how to do, what not to do, what to do. The Indian tax paying public and non-tax paying public is 70-30. You have 30% who are liable to tax who don't pay, then therefore there is this investigation, search and summons. As far as the people who are not paying the taxes, then they have to join the mainstream and pay. As far as the tax compliant are concerned, they also have to face all these investigation, search, summons. Therefore, how to face them has been one of the thought process. How to avoid dispute, because dispute is can be very costly and also can cause some very serious cash flow problem. The audit, which is going to become the important aspect of check and control in GST, we will understand in depth. We have got 9 how to prepare the annual return, how to what to look forward, how to get prepared for the audit by the chartered accountants or CMAs. Refunds are very important for those who are enjoying inverted duty structure or they are exporting, and therefore you have to understand that. We have also added a little bit of FTP, because it's important from the point that for the exporters, this could be quite significant. It can add 6-7% to your top line. Bottom line. Automation has become the order of the day. Even now we are using online, though we have some challenges. We are somehow managing. All of us working from home have problems of connections, and everybody sharing the bandwidth, so therefore your signals can drop. The last topic would be tax optimization and tax planning in GST, which I would be taking, and after that would be the individual queries, if any, for a couple of hours. We wish that you come, you can use the resources which we have shared in this particular PPT. I'm not going to get into it. I think there are a lot of good books in the market. Have a good look. And this course is 47.5 hours. I wish you happy learning. And over to, if there are any questions, they will tell me. Otherwise, I think they will take it over. And our first speaker, good friend of mine, Advocate Naveen, who is the understudy of my guru, Mr. K.S. Ravi Shankar, for some time. He will take over the session. Thank you very much. Enjoy your learning.
Session. Now I'm going to introduce the next speaker for the session. Advocate K.S. Naveen Kumar. Am I audible?
Yes.
Yeah. Advocate Naveen Kumar is a lawyer practicing since 2001. He specializes in indirect tax litigation and consulting and has appeared before various tribunals, courts, and legal forums. He provides advisory and representational services in insolvency matters. He has done BCom from Guru Nanak College, Chennai, from Sri Jagadguru Renukacharya College of Law, Bangalore, Masters in from Annamalai University, Tamil Nadu. He is the Vice Chairman, Central Indirect Taxes Committee for Federation of Karnataka Chambers of Commerce and Industry from 2007 onwards. Recently, he has been nominated as a member of the Indirect Tax Committee of Bangalore Chamber of Industry and Commerce. He has represented ASSOCHAM in Karnataka GST Grievance Redressal Committee appointed by the CBIC. He is co-opted member of National Executive Committee of Confederation of GST Professionals and Industries, presented papers on indirect taxes, including GST and other topics. He has co-authored 3 books titled Goods and Service Tax Primer, Compendium of Issues and Solutions in GST, Goods and Service Tax Act. With this brief introduction, I welcome Advocate Naveen Kumar sir to take up this session. Welcome, sir. I will be sharing your presentation by the while.
Yes. Can I start, Arjun?
Yes, sir, you can start. I will be sharing the screen at the due course.
Sure. Thank you. At the outset, I thank Hiregange Academy for inviting me to this webcast of GST course as the inaugural speaker. One thing which I have to acknowledge is that this lockdown has not knocked down our spirit of learning, and in fact it has provided much sought after time for relearning certain things and also revisiting legal classics, and also participate in seminars which has helped us to enrich our knowledge. So I have been asked to address you on some of the basic topics. I have divided the session into 2 parts. The first part would deal with the Constitution and legal maxims and its relevance to GST. Then we would also look at the levy, the taxable event supply, the schedules in the Act which are linked to the definition of supply in Section 7 of the GST Act. We would also look at certain incidental issues and definitions which are relevant. As was told by the first speaker, Mr. Madhukar, who introduced you to the course, my presentation would give you some of the basics of GST. In fact, it would lay the foundation for you to understand the other nuances of GST as we go along with the sessions which are to be conducted in the next 12 days. Next slide, please. Third slide. If you look at Constitution, a question would come why we should look at Constitution in the context of GST. The reason why we look at Constitution is it is the supreme law of the land, and all other laws, including GST, are subservient to the Constitution. Now, if you have to look at the Constitution, it gives the power to legislate. In fact, if you look at the Constitution before the amendments in 2016, it did not permit a system where you can introduce a tax in the nature of GST, where the center and state would come together to impose a simultaneous levy. So therefore, we had to make so many amendments in the Constitution, which ultimately led to the introduction of GST. What are those amendments? and why it was made, I would explain it further as we go on. One thing which I want you to bear in mind is that there are some issues which may crop up in the context of GST for which you would not have a solution in the GST law. So therefore, you have to look at the constitution and see whether those provisions are illegal or ultra vires the constitution. And that is where these two expressions, ultra vires and unconstitutional, become important. So whenever you want to challenge a particular provision or some levy of GST affects your fundamental rights, or where there is no alternative remedy, you would look at the option of challenging those provisions or circulars or notifications by filing a writ petition before the High Court. Next slide, please. Look at the salient aspects of the Constitution. If you look at the Constitution, it has what is known as the preamble, which states the purpose of the Constitution, and it starts with "We the people of India." It talks about various aspects like justice, liberty, equality, fraternity, etc. And the Supreme Court has interpreted preamble to say, in Keshavananda Bharati's case, that the preamble contains the basic structure of the Constitution, and they said that you can amend the Constitution in any manner, but ensure that the basic structure of the Constitution is not disturbed. So you can amend the Constitution in any manner, but you cannot affect the basic structure which is stated in the preamble. The next slide, fourth. Constitution also talks about the fundamental rights. What are those fundamental rights? How it is relevant to GST, I'll explain a little later. Then you have fundamental duties. In fact, in some jurisdiction, paying tax is also one of the fundamental duties. Of course, if you see Article 51A of our Constitution, you don't find that as one of the clauses. It would talk about developing a scientific temper. It would talk about protecting environment, abjuring violence, and excelling in all walks of life. So the fundamental duties were not originally part of the Constitution. It was introduced later during the 1970s. And I always say this, when you take care of the fundamental duties, then the fundamental rights of others are automatically taken care. Now, how these fundamental rights are important? Suppose there is a levy of GST on certain activities like a religion, or your freedom of movement is affected. Some of the fundamental rights are affected. In those cases, you can challenge the levy on the ground that it affects my fundamental rights, and therefore it is unconstitutional. I will give some examples as we go on with the fundamental rights. If you look at the other aspect, it is the role of legislature, judiciary, and the executive. Legislature makes the law, executive implements the law, and the role of judiciary is to interpret the law. So it is very clearly mentioned in the Constitution. But sometimes the judiciary also gets into the mode of suggesting laws or writing laws. That is called judicial activism. It does not happen quite often, but sometimes where there is inadequacy, they would suggest that this particular law should also be made. Then you have the directive principles of state policy, which are only recommendations to the various states regarding the policies which they should introduce and the governing principles which should be followed by them. It is not mandatory, it is only directory in nature. Then one more important aspect is the seventh schedule of the Constitution, which has three lists. List one is the union list, which states the field or subject on which the union can make laws. Schedule 2 contains the list where the state can make laws on various fields or subject. And the third list, which is known as the concurrent list, both center and state could make the law. If you look at the Constitution as it stood before the 2016 amendment, that is the 101st Amendment, which led to the introduction of GST, the union list did not authorize the center to levy tax, say on sale which happened within states. It did not authorize the center to levy tax on entry of goods. It did not empower the union to levy tax on entertainment. So it was all in the domain of the state. Similarly, the state could not levy tax or duty of excise on goods. Or excise on liquor they could levy. They could still continue even after the constitutional amendment. Liquor is a state subject, and if they want to subsume liquor, they have to do the entire exercise of amending the constitution, and then only they can introduce it. As of now, liquor is in the state's domain. Similarly, the state could not introduce a tax on services. It was under entry 97 in list 1, where the center could bring in service tax law. So these were the restrictions which were there in the past regime. So GST being a dual tax, where you have both center and state operating together, I would call it as a jugalbandi tax, a simultaneous levy of tax on a single taxable event, which is known as supply of goods or services or both. So this type of taxable event did not find place in the lists which were there in the 7th schedule prior to the constitutional amendment, and therefore they had to bring in the constitutional amendment, and more importantly article 246A, which specifically dealt with supply of goods or services, and they enabled introduction of GST. So this is a landmark amendment in the constitution which ultimately led to the introduction of GST. And now we have this concept of cooperative federalism, where all the states and the center and the union territories would sit together and decide what are the taxes to be subsumed, what exemption has to be given, what is the rate of tax, and therefore you have a constitutional body known as the GST Council, about which I would mention more when I deal with Article 279A. So, and there are certain other aspects relating to Constitution. Wherever it is relevant for GST purpose, I would touch upon that. Now let us move on to the next slide, which deals with fundamental rights. If you look at the fundamental rights, Article 13 proclaims that if you make any law which is inconsistent with the fundamental right, that law would be void. Who will declare it to be void? Only courts could declare. So for the courts to declare, you have to file a writ petition in the court and challenge it on the ground that it is inconsistent with the fundamental rights. Now Article 14 deals with equality before law. What does it mean? It says equals are to be treated equally. This is the court's interpretation of Article 14. Unequal should not be treated equally. They also said you can have something known as intelligible differentia. I will give an example in tax context. You take all the legislations which we had in the past regime. You had what is known as small scale exemption in excise and also in service tax. The same goods, if it is manufactured by a big manufacturer whose turnover is, let us say, 100 crores, they were supposed to pay duty subject to other exemptions. But if it is done by a manufacturer up to a particular limit, they were exempt from tax. So there is no discrimination because they are not equals. That is why the court said equals have to be treated equally, unequals should not be treated equally. So the government can differentiate between unequals and give some special privileges. In fact, if you look Article 14 deeper, all these reservation, etc., comes under Article 14 and intelligible differentia. I'm not going into those aspects as we are concerned only with tax. Similarly, Article 15 would say that you cannot discriminate on the ground of religion, race, caste, sex, or place of birth. Looking at 14 and 15, I would give one more example. Now we have all these advanced ruling authorities who are operating in all the states appointed by the government. Now let us say a particular assessee goes to the advanced ruling authority and they ask for a ruling, and the authority says your activity is not liable to GST. A similarly placed assessee goes to the same authority and asks for a ruling, let us say after 6 months. The advanced ruling authority takes a different view and says that you are liable to tax. So in that situation, the assessee can see whether there is a discrimination. You cannot discriminate between similarly placed persons. So what is the recourse available? Advanced ruling authority, we have an appellate authority also. Suppose you lose before the appellate authority also, there is no other remedy. Therefore, you have to file a writ petition in the High Court. And one of the grounds could be that there is a discrimination. Authority is giving differential treatment to different people. So this is one instance of discrimination under Article 14. Next slide, slide number 6. There are various rights to freedom in the Constitution, which are fundamental rights. For example, freedom of speech, expression. If you look at the service tax law and also the GST, you would see that this Press Trust of India, all this media is not subjected to tax when it comes to disseminating news, etc. Of course, advertisement, etc. would be taxable. Freedom to form association or union. Trade unions are not subjected to tax. Movement through territory of India. There are some exemption entries. If you go to the 12 of 2017, you would notice that some types of transportation of passengers is kept outside the ambit of tax, except situations where it is metro train or luxury train, etc. Then freedom to practice profession or carrying on occupation, trade, or business. Does it mean that imposing tax would affect your profession or carrying on occupation? In fact, these issues have been raised in some of the judgments. The court said that it is not an fundamental right, is not something absolute. There can be restrictions, reasonable restrictions are possible, which is enabled under Article 19 itself. Now let us look at, when you look at Article 19 and the other fundamental rights, you should always remember the exemptions which are there, where many exemptions are granted because they do not want to curtail the fundamental rights, like freedom of religion. Religious activities are not subjected to tax. So I will come to that a little later. Let us look at the next slide, Article 20. The focus of Article 21 is to say that in respect of an offense, they say that you see the law which is in force at the time of commission of offense, and then you can convict me or subject me to punishment. The second part of it would say, let us say there is a particular penalty, 10,000 rupees, when the offense took place. Legislature finds that 10,000 is too small, they increase it to 1 lakh. Adjudication happens after the amendment. Now, applying the principle of Article 20, You cannot impose a penalty of 1 lakh just because it was in force at the time of adjudication. You should look at the point of time when the offense happened and impose only that penalty, that is 10,000 rupees. So this is the essence of Article 20. Let us look at 8, the PPT number 8. There, if you look at 22, it says that a person cannot be prosecuted and punished for the same offense more than once. Just go back to the situation which prevailed in service tax law. 76 and 78 sections spoke about penalty. In most of the cases, the government or the department would impose both the penalties, propose both the penalties and show cause notice. The High Court applied this principle in a case called Motor World. I assisted my senior in that matter before the Karnataka High Court and before the tribunal also. There the court said, although there are 2 penalties, you cannot impose both the penalties. So therefore you have to choose, look at the offense and see what type of penalty should be imposed. You cannot punish someone twice for the same offense. Go back to the General Clauses Act, 1897. You will find a similar provision which embeds the principle of Article 22, which says that you cannot punish someone twice for the same offense. Then 23 would say that you cannot be compelled to be a witness against yourself. Now a question would come. Statements are recorded by various departmental authorities. Is it hit by Article 23? If you closely observe, it says a person accused of an offense. So in cases where statements are recorded, there is no offense. In fact, department also does not know, assessee also does not know what they want. They are only investigating the matter. Therefore, that would not be hit by Article 23 of the Constitution. This would be more relevant in the case of cases where a person is arrested by police and police cannot record those statements. That is why it is recorded before the magistrate. Next, Article 21 says that no one shall be deprived of his life or personal liberty except according to the procedure established by law. I find that this article is violated many cases in GST context. Wherever a person has not paid taxes, some sort of search and seizure happens, and without following any procedure, they directly resort to attachment of bank account, which in my view is violative of Article 21 of the Constitution. I remember one case law which I argued in the context of service tax law, where in one case, when the matter was being investigated, the proprietor of a concern dies. Within few days, the department goes and attaches his bank account, takes away the money. The investigation is not yet complete. Then when his family goes to the bank to withdraw money, to stake claim to that money which was supposed to be there, the banker says everything is taken by the department. Then they approach the High Court. And in the High Court, our argument was, you cannot put the cart before the horse. The argument was, you cannot straight away attach the bank account without even issuing a show cause notice under Section 73. That argument was accepted by the court. So even in GST law, you take all these cases where the goods are intercepted on the road by the mobile squad, they don't follow any procedure. The so-called issuance of notice, order, everything happens on the same day, although the law says you have to give adequate opportunity, etc. So these things very clearly violate Article 21 of the Constitution, and the remedy is to approach the High Court. Next slide. Right to education is also protected by the Constitution. It is a fundamental right. That is why if you see the exemption entry, the education up to a particular stage is not subject to tax. Predominantly, they are taxing only the commercial education. This was so even in the context of service tax law. It continues in GST also. Article 22 talks about protection against arrest and detention in certain cases. So if you look at 22, it says that a person who is being arrested should be told what is the offense he has committed, and he has to be produced before the magistrate within 24 hours. That is why you will find the officers coming to the premises after court hours on Saturday. Still, the courts have interpreted saying you produce him before the magistrate in his residence. That is the development of law. And the person has to be told why he has been arrested. So this protection is also given under Article 22. There are many cases where, particularly where there is circular trading in the context of GST, arrest provisions have been invoked, and wherever there are violations of Article 22, you can always approach the High Court. Next slide. It talks about the freedom of religion. Article 25. Freedom of conscience and free profession of practice of religion is a fundamental right. That is why you will have all these exemptions in the context of GST law. If you look at even the service tax law, they had kept the religious activities outside the purview of tax. So if there is an attempt to tax it, then it would infringe the fundamental right. There is a scope to approach the court saying that my freedom of religion is affected. Even Article 26 is related to that. Now 27, next slide, is a very interesting provision. It says you cannot collect taxes to promote a particular religion. That is, you cannot fund religion by collecting taxes. Talking about this freedom of religion, if you go back in history, you will find a particular tax called pilgrim's tax, which was imposed, and those type of taxes you cannot have it now because it would infringe the fundamental rights. Next slide. Similarly, you will have Article 29 and 30 talking about protection of interest of minorities, and Article 30 talking about right to establish educational institutions, etc. I've already told you, educational institutions up to a particular level are not subjected to tax. They are exempted. Now let us look at Article 32, next slide, which talks about approaching the Supreme Court directly. Wherever your fundamental rights are affected, you can directly approach the Supreme Court and say that my rights are affected. But in tax situations, rarely you find an occasion to approach the Supreme Court directly. But this article is used. I have seen many cases where in environmental matters, people have filed petitions directly in the Supreme Court. Public interest litigation cases filed in the Supreme Court. One instance which we all remember is we were asked to remove that black film which was there in the on the car window, and that was because of certain crimes which happened in Delhi. And Supreme Court passed an order saying that the home state has to create provisions to implement this type of law. In fact, that is one case of judicial activism where the court itself laid down the law, and later on the states brought in amendments. So wherever the fundamental rights are affected, you can directly go to the Supreme Court. Now let us look at one more aspect. The next slide, I have given the definition of India. I am not here to interpret the provisions of which is there in the CGST Act. I would just point out, you see the definition of India, the first limb talks about Article 1 of the Constitution. So if you look at the first article, it talks about all the states and union territories. So India would refer to all those states and union territories, but it is not limited to that. It could also cover territorial waters, seabed, subsoil, continental shelf, exclusive economic zone, then continental shelf. There is one law, which 1976 law, which you can see on the slide, which extends the territory of India to all these places. So this law has to be read to understand the meaning of India. It also includes the airspace above the territory and territorial waters. So here also you will find the relevance of Constitution. Next. I was telling you about the powers of Parliament and states. Prior to introduction of 246A, all the tax laws would be were legislated using the powers under Article 246, read with the 7th schedule. 248 would talk about a residuary entry 97 in the union list, which gave them power to legislate on any other matter which is not there in the state list. That is why service tax does not find place in the state list. Therefore, the union took it upon itself and imposed service tax law under Article 248 read with entry 97 of list 1. Next. 265 would say you cannot impose any tax without the authority of law. Here you will see both levy or collection cannot happen without the authority of law. About 3 or 4 days back, you had all these, you had one report of a Gujarat High Court judgment where they said that they tried to increase the limits, time limits in the VAT law. And the court said that you cannot do it because even the for collection, there should be an authority of law. So when all the old laws were repealed for the purpose of introduction of GST, the question comes whether you can legislate and increase the power or time limit which is there in the old law for the purpose of facilitating recovery, because we are facing a sort of emergency now because of the COVID situation. So this is something which I'm sure will go up to the Supreme Court. Even in Karnataka, they introduced some extension was done recently in the last week. Whether it is valid, because those laws are not in existence. Can you extend the time limit is the question. Then I will go to the next slide, which deals with Article 289. It basically exempts the property and income of a state from union taxation. It says exemption of property and income of a state. So it does not talk about indirect tax. It is only about income of a state, which is mentioned there, exemption of property. Then 300EA, which we generally use in refund matters, they said that you cannot deprive someone of his property without the authority of law. Then Article 226 and 227, next slide, deals with writ petition. If you look at the development of GST law, the number of writ petitions which have been filed in the High Court, there are some writ petitions where the constitutional levy of GST has been challenged in respect of certain transactions. For example, a question would come whether immovable property transactions can be subjected to tax. Those issues are pending before the High Court. And I have one matter where a writ petition has been filed in respect of duty-free shop. Duty-free shop is located beyond the customs frontier. Therefore, suppose the airport gives space to someone or lets out a premises within the airport to set up a duty-free shop, whether it would be liable to GST because it's beyond the customs frontier. So these type of issues cannot be agitated before the authorities who are statutory creatures, and therefore you have to approach the High Court for remedy. You will find a lot of case law development on many aspects. As the speakers would deal with several topics, they would highlight some of those High Court judgments. Similarly, wherever you are challenging a circular or a rule or a notification which is ultra vires the act, you have to approach the High Court. Then suppose the department does something like attaching your bank account, you have to rush to the High Court, ask for writ of mandamus or writ of certiorari, writ of prohibition. Then you are challenging the jurisdiction, you ask for writ of quo warranto, and in cases where arrest is made, habeas corpus can be filed. So these writ remedies are available under the Constitution. Now look at some of the definition. Taxation is defined in slide number 20. It includes tax or impost, general, local, special, and tax shall be construed accordingly. Then there is one deeming fiction which was introduced in 1982 to overcome some of these judgments. By virtue of this deeming fiction, they could introduce tax on sale of goods by the club to its members. The works contract could be taxed because of it. Restaurant activity could be taxed, and leasing of goods could be taxed. So this amendment, which brought in 366(29)(a), talks about deemed sale or purchase. Incidentally, I should mention that although they have brought in GST law, 366(29)(a) is still intact. When we go to Schedule 2, I'll point out instances where there is a conflict between Schedule 2 of the GST law and Article 366(29)(a). Now, GST is also defined in 12A. It means any tax on supply of goods or services or both, except alcoholic liquor. Alcoholic liquor is kept outside the purview of tax, only state can impose. Now look at this definition of service. Service means anything other than goods. Now the question is, can it cover even immovable property transactions? What are those immovable property transactions? I can even look at renting of immovable property, leasing of immovable property, giving license in respect of immovable property, looking at certain complicated transactions like JDA, joint development rights. Can it be subjected to tax? Now, just because they say anything other than goods, can you say that service definition is wide enough to encompass immovable property transaction? The reason is stamp duty is not at subsume in GST law. Therefore, you cannot increase the scope of the expression service. You have to read it down. And I'm sure many petitions have been filed, and this issue is going to be agitated up to the Supreme Court. When you look at the definition of immovable property, it is not defined in GST law, but it is defined in the General Clauses Act in a very wide manner. It includes land. It also includes the benefits which would arise out of land. It would cover things which are forming part or attached to the earth. Now, these benefits arising out of land has been interpreted very widely by the courts. It would also cover what is known as profit a pendre, which means the rights relating to land. For example, I give fishing rights. I have a pond. I give fishing rights to someone. That is actually in the nature of a benefit arising out of land. You take one decision of DLF in the context of service tax. They said that this transferable development right is nothing but a benefit arising out of land. They looked at the General Clauses Act, immovable property definition. They also applied a case law in the context of other laws like transfer of property law. There's one decision of Anand Behra. There's a decision of Bombay High Court in the case of Chaturbhuj. These decisions may have to be referred to in the context of GST law also. I see that there is a scope to argue that immovable property transactions cannot be covered by the definition of service. Now look at the definition of state. It includes union territory also. Now I will briefly tell you why this constitutional amendment came, and later on we will look at some legal maxims which are relevant to GST and then proceed further. I told you that the framework which we had earlier did not permit a Jugalbandi tax like GST. I only hope that it does not become a Jagalbandi. As of now, there is a lot of consensus in legislating. So now this, what they had to basically do was bring in what is known as supply of goods or services which did not find place in 7th schedule list 1, 2 or 3. So they had to introduce 246A, and 246A gave power to the parliament and the state to bring a law on of the nature of GST on supply of goods or services or both, and on intra-state supply, that is any supply within the state. As far as the supply interstate, the parliament has the exclusive power. That is why you have IGST law, which is made by the parliament. So you have CGST Act, you have SGST Act for intra-state supplies, you have IGST law for interstate supply. And there were different taxable events in the past, like manufacture, sale, then entry, then service provided or agreed to be provided. Now the only event is supply. What is supply? We'll see a little later. It covers supply of goods or services or both. This is Article 246A, which I was talking about, slide number 23. So I've already explained why this 246A was brought. Now they also say that in respect of petroleum products, the GST Council will decide when they want to bring. I don't see it in the near future, now that we are in a state where the economy is impacted and there's a lot of pressure on this petroleum industry. I don't think it will be subsumed in GST in the near future. Now, if you look at 269A, slide number 24, it talks about who should make the law. I've already told interstate supply, central government levies and collects the taxes. But it will be apportioned between the union and state. Then supply in the course of import, it shall be treated as interstate trade or commerce, and that is also covered by the GST law. In the case of customs, import of goods, there is a slight difference. I'll come to it a little later. Next slide. We'll skip 25, we'll go to 26. 279A talks about GST Council. If you look at GST Council, it has various members. It is headed by the Union Minister of Finance. State Minister is also there. Then you will have all the states being represented. So this is a constitutional authority now. and they take all decisions relating to GST, like rate, what are the taxes to be subsumed. In fact, the next few slides would talk about what are the powers of GST Council. They will make a recommendation on what could be the model law, threshold limit of turnover, rates, etc. So everything related to GST is done only by the GST Council. It also gives rise to a constitutional issue whether it affects the role of legislature insofar as GST is concerned. Because whatever they recommend is what is being implemented as law, and state has no say except passing the legislation which is recommended by the GST Council. So this is an issue which may crop up in future. Let us now go to slide number 31. If you look at some of the entries which are there after the 2016 Amendment Act, now the central excise is confined only to few petroleum products. So they have amended all those existing entries. The service tax related entry which was there, 92C, was removed. It was never used. So that was also removed. And Constitution also defines services means any other good, anything other than goods. Next slide. One important issue before I wind up my discussion on constitutional aspects is that if you look at section 19 of the Constitutional Amendment Act, it says that they gave a time limit or a sunset clause. They said that all the previous laws will come to an end within 1 year from the date of introduction of the constitutional amendment. We all knew that Constitutional Amendment Act was introduced from 16 September 2016, and within a short time GST law was implemented. So if you take 1 year from that day, then 15 September 2017, the expiry date section, sunset clause. Now, an important question came up. If you look at GST law, section 174, which is the repeal and saving clause, says that it saves all the rights, liabilities which accrued under the old regime. Now, can it be exercised now? Is the question. Can they issue a show cause notice to recover VAT? Can they issue show cause notice to recover service tax? The argument before the court was that you cannot use those earlier provisions because of section 19, which puts in an expiry date. You had a limited window which has already expired, and therefore you cannot exercise powers even under 174, because 174 of CGST Act is subservient to the Constitution. This argument was not accepted by the Kerala High Court in Sheen Golden Jewels, and they said that Article 246A itself is sufficient enough to encompass those powers and save those powers. I think it is now pending before the division bench. So even the Karnataka High Court has not accepted this argument. The issues which may come up is, can they do audit, service tax audit now? Because audit was earlier done by virtue of Rule 5A of the service tax rules, which was challenged twice before the Delhi High Court, struck down. Again, they introduced. So the question is whether rule is saved. There is a decision of the Supreme Court in Kolhapur Kenshu's case. They say that Section 6 of the General Clause Act, which is also made applicable to 174, does not save the provisions of the rule. It saves only the act. So rules cannot be enforced under 174. Similarly, Sanvat cases, demand is under Rule 14. Is it sufficient? Can you invoke that rule which has already expired, not saved by 174? And similarly, the DGCI, which was a notified authority, can they exercise the notification powers to investigate some excise or service tax evasion? So these issues are now pending before the court. Now let me go to one more aspect. I'll spend about 15 minutes of it and then go to the GST law per se. Now there is something called legal maxims and legal phrases, and most of these legal maxims and phrases are in Latin. The reason is we have adopted British jurisprudence, which in turn comes from the Roman system of law which they had during medieval period of history, the Roman law, and therefore these Latin maxims have become a part of our law also. In many cases you will use these Latin maxims. So a person who practices GST law should know the constitution. He should also know certain general principles of interpretation. He should know the evidence law. He should know the General Clauses Act. He should know the transfer of property law, because many principles come from other laws. So these other laws will give them insights to interpret the GST law. So one such thing is the legal maxims and phrases. I will take up few of them to explain how these legal phrases and maxims are useful in GST context, or while reading or arguing cases in the context of GST law or interpreting the GST provisions. There is one phrase called locus standi. Who can go to the court? Can anyone go and fight a case? Can a lawyer fight a case saying that I am filing this petition because this particular provision is illegal? I have to show that I have a locus standi, that I have been affected by the particular provision. So this is called locus standi. The court will ask, who are you to come to the court? Don't fight a theoretical case. So if you want to fight a case, you should have a cause of action or a locus standi to approach the court. This is the meaning of locus standi. Mutatis mutandis. That means with all the necessary alterations and changes. Look at section 20 of the IGST Act. This expression mutatis mutandis is used. It makes applicable many provisions of the CGST Act. Many provisions of CGST Act are imported into IGST Act. They do not want to repeat those provisions. They say with all the necessary changes, apply it to IGST law, like such, seizure, all those ITC related, appeal related, many provisions are brought into IGST law. So there this mutatis mutandis is used. Modus operandi. You find this in some orders or orders of the court or authorities, or in the show cause notice. Show cause notice would say the modus operandi adopted by the evader is so and so. They will explain the facts and say this is the system or the particular method in which they operated, which led to the alleged offenses. Non-obstante clause refers to the expression notwithstanding. You will find this expression used everywhere in GST law, many provisions, including section 7, with which we are going to deal with, which defines what is supply. So when they use this expression notwithstanding, it means that particular provision overrides the entire law, or it overrides any particular provision of the GST law. So this is how you understand notwithstanding. Per incurium means a particular judgment was rendered without noticing the law or facts. So there you will try to distinguish a judgment saying this judgment is per incurium because their lordships have not looked at the facts, or they have not looked at the law or the other case laws on this aspect. Re integra means anything entirely new or untouched matter. For example, the courts would say that this issue is already dealt with in another judgment. Therefore, the issue is not re integra. Ratio decidendi basically means the reasoning which you find in a particular judgment. So when you read the judgment, you always look for the ratio. So you have to see what is the principle laid down by the court. This is called ratio decidendi. Ignorance of law is not an excuse, but ignorance of fact is an excuse. The courts apply this principle to say, you cannot say that I did not know that from 1st July 2017 GST law has come, therefore I have not paid tax. So you cannot use ignorance of law as a defense. But ignorance of facts while recording statement relating to 2014 or 15, you can always say that I have to check those facts while the statement is being recorded. Even if you have given something wrong, you can always go back, check the documents, and share an affidavit, say that out of oversight I have stated this, but this is the correct position of fact. Lex non cogit ad impossibilia. Law forces not to impossibility. This principle is going to be used in GST law again and again. This is also linked to the next maxim. You cannot compel someone to do the impossible, is the effect of this maxim. So as we go on with the subject, you will find there are many instances where this principle has been applied. For example, while filing your Tran 1 returns, technical glitches were there, I couldn't file it. The courts have permitted applying this principle of law. Ejusdem generis on nocitar sources is used while interpreting certain definitions. For example, you will find some expressions which are used. Let us say that there's a definition of animal. Animal is defined, let us say, to cover cats, dogs, cows, and the like. Can you include tiger and lion is in that category? So there you would go by ejusdem generis, and the like, or other animals cannot encompass something which is not stated earlier. So it covers, intention is to cover only domestic animals. So when you look at the definitions of GST law, you will be applying this principle of nocitar aesosis, which talks about birds of same feather flock together. That is the principle which is used to interpret certain words which are general in nature. So the principle here is, the next slide would talk about 37 slide. Special law repeals the general law. There are some provisions in the GST law. For example, if you fail to appear before the authority who has issued summons, it is an offense under IPC. There are also certain other provisions in IPC regarding public servants. Those provisions are also there in GST law. So the GST law, which is a special law, overrides the general law. That is the effect of it. A person cannot be vexed twice for the same cause. In the context of Article 20, I have already explained this. See the last one. No one is to be punished for a crime or wrong of another. Suppose the proprietor dies. He has committed some offense. The business is taken over by his wife. You cannot punish the wife, and you cannot punish the dead man also, because he is not in existence. The law in some circumstances may provide for recovery of duty from the legal representative, but you cannot impose a penalty. Now let us look at few more and then go to GST provisions. I will take up the second maxim, ubi jus ibi remedium. Where there is a right, there is a remedy. There are many cases where you will find that the law does not provide a remedy. For example, advanced ruling authority says your activity is liable to tax. Beyond the appellate stage, you don't have any other remedy. Therefore, the remedy is to go to the High Court. So, law always provides for a remedy, is the understanding. Where there is no principle, there is no accessory. Where there is no tax, there is no interest. This is the principle in the context of GST also. Now look at, I will skip the next slide and go to 40. Audi alterum partem. Natural justice requires that you should hear the other side and then take a decision. Any authority who passes an order should hear the other side. This is also a legal principle. Mens rea. Mere action alone is not sufficient. It should be accompanied by the guilty mind. In many cases, the provisions talk about penalty. They don't talk about guilty mind or mens rea. There are decisions. You read Supreme Court in Hindustan Steel and the Karnataka High Court in Indus Towers, which I argued. They say even if the law is silent, you can read attribute mens rea element into that. So this will be useful in the context of GST also. A person cannot be a judge in his own cause, but this is not followed in tax matters. Person issuing the show cause notice and adjudicating is the same. So this is a general principle which is overridden by the special law. A personal action dies with the person. Section 73 says you can recover the tax only from the person chargeable to tax. What if the proprietor dies? The case dies with the person. Read Shabina Abraham's case, Supreme Court, in the context of excise law. You will understand what I say. The last one, law aids the vigilant and not the dormant. There are various time limits which are prescribed. Take Tran 1, you are supposed to file before 27th of December 2017. Many people missed out. For people who had technical glitches, they got favorable orders from the court. People who were negligent, this maxim will hit them. Similarly, time limit for refund, even for the department, time limit to recover, they should be vigilant and not dormant. So this is how the legal maxims will be useful in understanding the GST law. Now with this background, I will give an introduction of the levy of GST, and then we'll take a break, say by about, I will go on up to about 11:20. Then we'll take few questions on the topic covered. We'll have a break and then come back. Slide number 42. If you look at the GST law, it is intended to tax a taxable event called supply of goods or services. What is supply of goods or services? We will see a little later. I will take you through section 7, schedule 1, 2, and 3. Now, this expression levy is important. What is levy? It is also known as charge. It is different from exemption. Levy or charge of tax is attracted when the taxable event happens. That is, there is a supply of goods or services or both. Levy is attracted. Then the collection happens. Sometimes the levy is attracted, but the collection may not happen. There may be some exemption, like 12 of 2017, or the one which you have under the for goods. So although there is a levy attracted, the collection does not happen, and it is known as exemption. The government has powers to exempt certain goods or services where the tax rate becomes nil. That does not mean that levy is not attracted. In PK re-rolling mills case, the Supreme Court said if the levy itself is not attracted, the question of exempting it would not arise. So unless there is a levy, there is no need to exempt something. And just because there is some exemption, that does not automatically mean that levy is attracted. You cannot determine a levy based on an exemption notification. This is the point which I want to drive home. You will find that many things find place in the exemption list, but is it liable to tax in the first place is the question which you should ask. Now, if you look at the GST law, the charging provision is section 9 in CGST Act and section 5 in the IGST Act. CGST and SGST deal with intrastate supplies, and IGST deals with interstate supplies. It also deals with the import of services. Now, when you look at section 9, it also talks about certain notified cases where levy would be attracted in the hands of the recipient of the supply. For example, you have 9.3 and 9.4, which talks about reverse charge mechanism, as you call it. The reverse charge mechanism was there in the service tax law also. We have adopted it in GST context. And there is this one provision, 9.4, which talked about reverse charge in case the supply is received from unregistered persons. This was posing difficulty, and therefore they suspended it after some time. And now, if you look at 9.4, it applies only in notified cases. But there is a vacuum for the period from 1st to July till a particular date in October. What happens to the levy, whether the recipient should pay or the supplier should pay, will it be attracted, will it be exempted, is a big question. Now, so basically it deals with what are the services covered under reverse charge, what are the goods covered under reverse charge. Those things would be taken up by the other speakers when they deal with reverse charge. I'm not going into that aspect. I'm just giving you broadly the framework. And section 9.5 talks about e-commerce operator, where the supply happens through an e-commerce operator. To give examples of e-commerce operator, it is like Ola, Uber, Amazon, Flipkart. These are instances. These are e-commerce operators who allow supplies to happen through them. And e-commerce basically refers to usage of a digital platform or an electronic platform to effect supplies. So in those cases, what the law says is that in notified cases, the e-commerce operator would themselves pay tax under. It is also a form of reverse charge. And for example, you have all these taxis, Ola, Uber operating, who are notified for the purpose of 9.5. And similarly, you have these accommodation services, which are also covered by 9.5. And there is a concept of tax collection at source. I will just briefly mention, as it would be dealt with later. So section 52 says a person, in the cases where supplies are happening through an e-commerce operator, the e-commerce operator is supposed to deduct a certain percentage, say 1% of GST. It is called tax collected at source. It is not TDS. TDS is different. It's tax collected at source remitted to the government, basically to track people who operate through the e-commerce operator and to bring them to tax, to trace them. That is the purpose of this provision. Now, when you look at section 5, that also deals with charging section, basically interstate supplies. Now, what is interstate and intrastate supply? Intrastate supply, the criteria is this. When you go to place of supply related provisions, you will deal with specific instances. Here, the criteria is very simple. Look at the location of supplier, also look at the place of supply. If they are in different states, then it becomes interstate supply. If they are within the same state, then it is in the nature of intrastate. There are specific provisions in the IGST law dealing with place of supply, and there is a definition of location of supplier, how to determine what is location of supplier, which would be dealt with more elaborately in the context of a registration and also in the context of place of supply. I would not go into that aspect very deeply at this stage. Now look at the slide 43. Basically, in case of intrastate supplies, there are two taxes. One is the CGST, another one is SGST. So you have a Jugalbandi system of tax imposed by the state and also by the center. So a particular intrastate transaction would attract both the element of CGST and SGST. And when it comes to interstate transaction, next slide, you have what is known as IGST, integrated GST, imposed under the IGST law. Now, by virtue of this, stock transfer from one state to another between branches would be liable to tax under the GST. You look at the old model, under the CST law, stock transfers are not subjected to tax. But in GST, since they are treated as distinct person, although they are part of the same entity, for the purpose of GST, they are treated as distinct person, and therefore when you transfer goods, it becomes liable to tax. There is one more controversy which came about because of an advance ruling issued by the Karnataka authority in the case of Columbia Asia. There they went to the extent of saying that there could be a cross charge. There may be a need to cross charge services provided by the head office to the branch and vice versa. And the employees, the cost of salary, etc., needs to be cross charged because they are also working for other branches. So this is a very controversial advance ruling which has come about, and there may be, it goes against the basic principle of law that one cannot do business with themselves. You cannot do business with yourself. This is the basic principle of law, and you can look at a lot of judgments, including Sir Kikabai Premchand's case, where they expounded this principle. Can you earn income by transacting with yourself? Is it a business? Is a basic question which has been challenged in the court. Of course, in some cases, taking a conservative view, you can pay tax. For example, a chartered accountant firm having branches in 2 or 3 other places, other states, the head office would like to cross-charge some of its whatever services are given by them to the branches. But cross-charging of expenses, is it required? Does it defy the principle of one cannot do business with oneself is an issue which has cropped up. We have to see how the law develops. Next slide. You look at the definition of business in the GST law. It is defined in section 2 of the GST law in a very wide manner. I'm not reading out the definition. I'm just drawing your attention. I would recommend that you should deeply look at this definition because it has as many as about 8 or 9 clauses. It is an inclusive definition, and they also say that it includes trade, commerce, manufacture, profession, vocation, etc., other similar activity, whether or not for a pecuniary benefit, and even incidental or ancillary activities are covered. Volume frequency is not material. So the question which crops up here is, are charitable activities covered within the purview of business? For example, I may set up a charitable organization with charitable objects. It is covered under income tax exemption. ATG is also there. Let us say I'm promoting the teachings of a particular guru, and I am selling some CD and other literature books. Can you say I am indulged in business? These issues cropped up even in the context of old VAT law. And there you would find the definition, the courts, there's one decision of the Supreme Court in Sai Publication Fund. The Supreme Court said that the person is not a dealer because they are not engaged in the business. Their object is charitable. Therefore, you cannot be saying that they are engaged in business. The reason I am pointing out is when you look at the definition of supply, you would be seeing that there is a reference to in the course or furtherance of business. I will deal with that aspect a little later in the second half of my presentation. So this business definition is very wide, but will these type of activities covered? You look at the exemption entry, it does not exempt all charitable activities. Charitable activities defined in a particular manner alone are exempted. So this is an issue which I'm sure will go to the courts. Then the definition of service also is important. Constitution definition we saw. A similar definition is also adopted in GST law. And it says it means any goods, anything other than goods. Anything other than goods, money and security. Security is defined under the SCRA, Security Contract Regulation Act. That definition has been borrowed. So it also includes activities relating to use of money or conversion by cash. For example, foreign exchange. I give my Indian currency, get foreign exchange. They impose some costs or they impose some charges. That will be subjected to tax. But I go and deposit money in the bank. You cannot tax it. I transfer money to my branch. It is a transaction in money. So service means anything other than goods, money and security. Does it include immovable property transaction? I talked to you about it some time back. Now look at the definition of goods. Goods is also defined to cover every kind of movable property. Contrast this with the Sale of Goods Act. It is slightly different. It means every kind of movable property other than money and security. Here also they exclude money and security, but they include actionable claim, growing crop, grass, and things attached to and forming part of the land, agreed to be severed before supply or under a contract of supply. What is actionable claim? They refer to the definition in section 3 of the Transfer of Property Law. Basically, it deals with acknowledgement of a debt other than those relating to immovable property or pledging of goods. In fact, the development of law in section 3 of the Transfer of Property Law, it has been a highly litigation prone area to understand what is actionable claim. Fortunately, in GST law, they restrict the levy only to betting, gambling, and lottery. Therefore, we need not break our head understanding what is actionable claim. So, the next slide, you will find IGST levy. One thing which I should point out here is, in the context of IGST, in respect of import of goods, it is the provision 5(1) proviso says you go to the customs law and it would suffer tax. IGST would be imposed at the same time when customs law is imposed and on the value determined under the customs law. So you go back to section 3 of the Customs Tariff Act, where it talks about imposition of IGST on import of goods. So with this, I will take some questions till what we have already seen. In the next session, we will be looking at the supply and various types of supplies which are subjected to tax. So if there are any questions till now, I would be pleased to answer that.
Yes, sir.
Yes, please.
The first question, can you provide any legal precedent where double penalty cannot be levied on an assessee?
Motor World's case, section 76 and 78 context, service tax law, Karnataka High Court judgment, which is also reported in TIOL and Excus. You can read the judgment.
Yes, sir. The one more question. In case of difference between the council decision and the law,
yes,
which has to be prevailed for the purpose of this disputes and getting the decision from the court.
Difference of opinion between council and
the law. They have not yet amended the law. However, they have taken a decision in the council.
Okay. See, in those cases, if for example, that section 51 interest, that is a controversy which is going on, whether it has to be on net amount or gross amount, and the Telangana High Court gave a verdict saying that it is on the gross amount. So in those cases also you had a recommendation which came later, which is yet to be made retrospective. In those cases, you cannot, at best you can go to the High Court and say, wherever there is an attempt to recover, you can say that there is already a recommendation on this point by the GST Council, but the provisions are yet to be brought into force by way of legislation or a notification. So we can ask for a direction to keep the proceedings under abeyance. This is the remedy which they can seek. And whenever there is a recommendation made, you can also ask for a direction for speedy implementation. The court can give, although they are hesitant in giving directions to the legislature, to the government, okay, but the legislature, they are generally hesitant. Yes, sir. Next.
Okay, sir. Can a law be passed without approval of Parliament?
You cannot pass a law without the approval of Parliament, because the power to legislate is only with the Parliament or the state legislature. And moreover, in the context of GST also, 246A specifically says that the law has to be enacted by the Parliament or state legislature. There is no way you can bring a law in the nature of an act by bypassing the Parliament. Of course, there is something called delegated legislation. For example, notification, rules, exemptions are all issued in the form of a notification, and for which you don't require Parliament's approval because the Act itself has empowered them. The only process which is followed is those notifications are later placed before the Parliament or state legislature. So that is the process which is also recommended in the CGST Act or the IGST Act. Yes.
Yes, sir. The last question before we go for the break.
Yes.
Balance
Yes.
questions will be answered at the end of the session. So last question before the break, sir. In the light of PK re-rolling Mill's decision, whether
Yes.
interest on deposit can be said to be a leviable services by just inserting an entry in exemption notification.
No, that is what I was saying. You cannot decide about levy based on exemption. It should be in the nature of a supply. What is not in the nature of a supply cannot be just kept out of the ambit of tax, because an exemption can be removed by issuing a notification. Whereas to attract a levy, it has to be done by the parliament or the state legislature. So therefore, you cannot decide the taxability based on exemption. That is how you should look at it. And whenever there is a doubt, you should you have the scope to challenge it before the court, saying that the levy itself is not attracted. Where is the question of exempting it? Who are you to exempt when the levy itself is not attracted? Yeah.
Okay, sir. By now we can go for a break. We can reconnect by 11:45 or 11:50.
No, you tell me either 11:45 or 50.
11:45.
Okay.
11:45.
Fine.
So we can by 11:45. All the attendees, you can raise question in the Q&A portion. We will be considering your question at the end of the session. Now we will go for a break and we can reconnect by 11:45.
Arjun.
Yes, sir. Hello. Hello. Hello.
Hello. Arjun?
He'll join, sir. I think he's online. He'll join.
Start. You can resume the session, sir. I will start presenting your
Okay.
PPT.
Yeah. Welcome back, participants. We would now go to the supply part. Before going to the supply definition, I would also bring to your notice that under section 10 of the GST law, there's something called a composition levy, which predominantly applies to goods suppliers and to services also to a limited extent, like restaurant, etc., where a fixed percentage of tax is paid and even the compliance burden is lesser as compared to normal taxpayers. The procedural part of it as to what is the compliance to be done, registration, etc., would be dealt with by the other speakers. I just wanted to mention that there is also something called as Section 10 composition levy. So now we will get into supply, which is the basic provision which defines the taxable event. So to understand GST law and to apply GST law to various facts, we have to be conversant with the definition of supply enshrined in section 7. There are many gray areas and many issues which are being debated, and I am sure that at the end of my session you will be left with a lot of doubts and issues which I would suggest that you should note and keep. And as you go on with the course for the next 13 days, you would be in a position to hear from other speakers, and you yourself will discover and get many insights on various aspects of supply. To the extent possible, I will also try to address some of the issues which you may raise at the end of the session. So taxable event is defined in section 7, and the same definition is adopted in IGST also. So they do not want to again reinvent the wheel. They adopt the same thing because the taxable event in the GST law, whether it is CGST, SGST or IGST, is same. Supply of goods, services or both. There is one major amendment which they brought in 2018, which was a retrospective amendment, which according to me has a very wide ramification. When I go to schedule 2 and the relevant definition, I will explain how it is going to retrospectively affect the position taken by the assessees in determining whether their activity is supply of goods or services or both. Now, supply definition section 7 is also linked to schedule 1, 2 and 3. That also we would look at. Now I would request our friend Arjunan to display the provisions of section 7, which we would look at so that we will understand how the taxable event has been defined and what was the amendment affected recently and what is the implication of it. So if you look at the definition of supply, it basically refers to if you see the definition of supply, it is an inclusive definition. In law, you would find the expressions defined and they use the expression means. So when they use the expression means, then you can read it as mathematically as equal to. When they say includes, you have to add a plus there. So they, apart from your normal understanding of that expression, they also want to include something. Sometimes they also use an exclusion clause. It means so and so and it excludes so and so, or does not include so and so. Like what we saw in the definition of goods, it does not include money, securities. So that is the exclusion clause. Sometimes they also say it means and includes so and so. That is also used. So here, if you see section 7, it covers all forms of supply. Please, you have to emphasize on the expression all forms. So they want to capture everything which can be conceived or perceived as supply of goods or services. And they would also say goods or services or both. Some transactions may involve both goods and services. That also they want to capture. Then they say such as sale, transfer, barter, exchange, license, rental, lease, disposal made or agreed to be made for a consideration by a person in the course or furtherance of business. Now, what is goods? We have seen. Service is defined to say anything other than goods. This is where I was raising an issue whether it would encompass immovable property transactions. The definition of immovable property in General Clauses Act is very wide to cover land, benefits arising out of land, anything forming part or attached to earth is also immovable property. Benefits arising out of land has been interpreted by the courts. Fishing rights is a benefit arising out of land. Service tax, Sestat has decided DLF case, transferable development right is in the nature of benefit arising out of land. So even a benefit arising out of land or an interest in land is treated as immovable property. Immovable property does not, you cannot confine that expression only to the ownership, because with respect to immovable property, you read the Sunil Siddharth Bhai's case in the context of income tax, where the Supreme Court said this immovable property is a bundle of rights. It may be right of ownership, right of possession, right of use, right of destruction. So one of those rights, if I transfer, one of those benefits I give to someone, is it in the nature of immovable property, therefore outside the ambit of GST is the first issue which I would place for your consideration. Now I would take you through one particular clause in Schedule 2 of the GST law. Since we are discussing this aspect, I would request Arjunan to kindly go to Schedule 2 and refer to clause 2 there, which deals with land and building. So you would see on the screen, there is one clause which deals with land and building. Please see the expression. This clause is meant to look at only land and building. And what is the heading of Schedule 2? It says activities or transactions to be treated as supply of goods or supply of services. Now, what is the effect of it? It says any lease, tenancy, easement, license to occupy land is a supply of service. So they say it is in the nature of service. But the basic question is it a service at all? Now look at the clause B. Lease letting out of building, including a commercial, industrial, or residential complex for business or commerce, either wholly or partly, is a supply of service. So they deem that these activities are in the nature of supply of services. But one thing which I should bring it to your notice is the provisions of 7(1)(a), which was introduced by the 2018 amendment. Actually, it was a retrospective amendment inserted with effect from 1/7/2017. If you look at the Schedule 2 per se, and compare this with your declared service which you had in the context of service tax law, most of these entries are borrowed from there. You all know that declared service means it is deemed to be a service. Whether it is understood as service as per the definition which existed under 65B(44) of the Finance Act, it was declared to be a service, deemed to be a service. Now, when they introduced GST law, they found it convenient to borrow directly from declared service instead of reinventing the wheel. So they borrowed most of the things from declared service. Now this 7(1)(a), which is the amendment which I am referring, introduced a major amendment which probably would change or alter the tax position taken by many assessees. It says certain activities or transactions constitute a supply. Where certain activities or transactions constitute a supply under 1, they shall be treated either as supply of goods or services as referred to in Schedule 2. That means if something is already a supply as per 7(1), which we were looking at, 7(1) we saw covers covers all forms of supply of goods or services or both. They also give some illustration. It covers import of services, and it would specifically cover certain things which are mentioned in Schedule 1. Now the question is whether this immovable property transaction referred to in Schedule 2, Clause 2, can be treated as service for the purpose of 7(1) so as to automatically call it as service or a deemed service as per Schedule 2 is the question. My view is that if you apply the principles of General Clauses Act, you also read the definition and case laws which are there in the Indian Registration Act, the Transfer of Property Law. All these are old laws which are about 100 years old. So the amount of case laws you would get under those laws with respect to immovable property transaction is immense. So when you apply these principles, there is a case to argue that supply till stamp duty is subsumed cannot encompass immovable property transaction. Therefore, since it is not a supply, the question of calling it a service under Schedule 2 would not arise in law. So the effect of Schedule 2 after the 2018 amendment is it has been reduced, the utility has been reduced only for classification purpose. So something should already qualify as a service or goods, supply of goods or services under 7.1, and then you look at whether I should call it as service or goods for the purpose of GST law. So it is no longer a deemed supply of goods or services. So this observation I want to make in the context of section 7. Now going further, 7.1a, I would request Arjun to get back to 7.1. You would find the expression used such as. If you look at the definition of input service, which was there in the SENVAT Credit Rules 2004, prior to its amendment somewhere in 2011, it said activities, input service would also include activities relating to business such as. This expression such as was interpreted to mean only illustrations. So to understand all forms of supply of goods or services or both, they have also given some illustrations. They say sale is covered. Sale was earlier covered, which attracted VAT intrastate, or if it is interstate, CST was levied. Then transfer is also covered. Transfer of goods between branches was not liable. Now transfer is covered here. Now barter. Now the question would arise. Suppose I transfer goods from Bangalore branch to Salem branch. Is it liable under 7.1a? You read the definition further. It says it should be made for a consideration. So per se, between head office and branch or one branch to another, 7.1a is not sufficient. There is one more schedule 1, which I would refer to. Using that, you can tax between distinct persons. So now you look at the other expression. Barter is covered, exchange is covered. In fact, I would also draw your attention to one decision of the Karnataka Appellate Tribunal in the context of the VAT law, where in a case called Vaswani Developers, where the tribunal said these joint development agreements are in the nature of a barter, and therefore it cannot be subjected to VAT. That decision can also be looked at in the context of GST law. Insofar as the services provided by the developer to the landlord, there may be a possibility to refer to L&T and say there is a service. But when the landlord gives the development rights, it is possible to take a view. One, it is immovable property. Second thing is, in the context of service tax, we have taken a view that it is not in the nature of, it is in the nature of a barter, therefore not liable to tax. It covers exchange, it covers license. License, not in the context of immovable property, it is license, let us say software license. That is one good example which we can give. So you should use this expression such as sale, transfer, etc. Everything is linked to supply of goods or services. Now it also covers renting of or giving the right to use goods, leasing of goods, disposal of goods, made or agreed to be made for a consideration. So made or agreed to be made for a consideration would mean, it may be past consideration, present consideration, or future also. I receive advance and I'll tell him that I'll render the service after 6 months. Since you have received the advance, it would be subjected to tax because it becomes a supply. And it says it should be made by a person in the course or furtherance of business. The definition of person in the CGST Act has to be looked out, which is wider than what is defined in the General Clauses Act 1897. It also covers even government, local authority, etc. Now look at the second part, 1B, import of services for a consideration, whether or not in the course of furtherance of business. Contrast this with clause A. Clause A says it should be for a consideration by a person in the course or furtherance of business. Now come back to the discussion which we had in the first part when we looked at the definition of business. Can you say that a charitable institution is engaged in an activity which is in the course or furtherance of business when they actually indulge in charitable transactions or charitable activities? So this, I think, would lead to litigation, as the definition of business is very wide and it is also vague. They could have clearly specified. If they wanted to tax it, they could tax everyone by specifying it in the definition itself. Instead, they have left it to interpretation. Now, the second clause does not say it should be in the course or furtherance of business. That means I can import some service which may not be in the course or furtherance of business, but still it may be subject to tax. But I would also draw your attention to some of the exemption entries. If an individual receives some services, they have given exemption. If government receives some foreign services, they have given some exemption. So levy is attracted, but there are exemptions which are available, which would be dealt with as we go along with the other sessions. The third clause there would say activities specified in Schedule 1 made or agreed to be made without a consideration. So this leads us to Schedule 1. So they also say Schedule 1 activities may or may not be without consideration. Even if there is no consideration, they would treat it as supply of goods or services and would be subjected to tax. Now let us look at Schedule 1. Arjun, can you just open Schedule 1? We'll have a look at it. If you look at the first clause of Schedule 1, it says permanent transfer or disposal of business assets where ITC has been availed on such assets. Now this has opened up a Pandora's box, because they say if you transfer or dispose business asset, the expression business asset is not defined. So you have to assume, you have to bring in your accounting concepts and interpret what is business asset. Any asset relating to business can be treated as business asset. And there is also a condition: if you have taken ITC and if there is no consideration, you dispose of your business asset, then it would be treated as supply and you have to pay tax. How you value, etc., would be dealt with in the context of valuation provisions. I will give few examples. Suppose you have old furniture on which you have taken credit, ITC. The furniture is damaged. You ask your office boy or clerk or driver and tell him, please take it away. We do not want it. We want to buy a new one. If you have taken ITC on those furnitures, then it would trigger clause 1 and it would be subjected to tax. So this is the implication of this permanent transfer or disposal of business asset. It also gives rise to some issues. Like, for example, I have printed and kept, I'm a pharma company, I have printed and kept some advertisement material or promotional material. I go and give it free. Let us say I have taken credit on this printed material. Does it trigger clause 1 of the schedule 1 is a question. Or suppose I give free samples of goods which I have purchased. Let us say I am a trader. Does it attract permanent clause 1? Is there a permanent transfer or disposal of business assets? So is it a business asset? In what sense you would understand the expression business asset? So this is something which has given rise to several issues, and this should always be kept in mind wherever credit has been availed on some business asset. There may be a difference. So for example, I have purchased something, but I have written off in the P&L account. I have not capitalized it and shown it as a business asset. Does it mean that you can dispose of and clause 1 is not attracted? So this business asset expression usage, because everywhere in supply they deal with the expression goods, but here they bring in the concept of business asset, which is vague. Now let us look at clause 2. Supply of goods or services or both between related persons or between distinct persons as specified in section 25 when made in the course or furtherance of business. Who is a related person? You will understand it when you go to the valuation provisions. Distinct person as defined in 25. For example, the head office in Bangalore and the branch in Pune are treated as distinct person requiring separate registrations. So once you get separate registration, although it is forming part of the same entity, it is a part of the same company, but the law deems it as a distinct person, and schedule 1 triggers and it says those activities or transactions would be treated as a deemed supply attracting GST. So this is where even there is no consideration, it would be subjected to tax. Now proviso there would say that any gift not exceeding rupees 50,000, which is in a financial year, by an employer to an employee shall not be treated as supply of goods or services or both. Now, whenever gift is given, it may be a gift of goods or services. If it is part of the employment contract, then it is possible for you to say it is covered by Schedule 3, because Schedule 3 says any service given by employee to employer pursuant to an employment contract would not be considered as supply of goods or services. But if it is not a part of an employment contract, then if some gift is given, let us say there is a wedding of an employee and the company gives a gold chain worth 1 lakh rupees, then it would trigger this proviso, and therefore for each employee they have to keep a tab of gifts to see whether it triggers Schedule 1. Then clause 3 deals with supply of goods by a principal to his agent, and similarly an agent to his principal. So any transaction between a principal and agent would be deemed to be a supply. He may be a consignment agent. I would be sending goods to him, not for a consideration. He stocks it and sells it later. But the law requires that it should be treated as supply of goods. That means accounting wise, the transaction is not treated as sale. Your P&L account may not reflect it as a sale, but Schedule 1 deems it as a supply. So therefore, for GST purpose, you would be required to reflect it as a supply, pay taxes on that. Of course, the recipient would take credit, all those things would happen. So there is a deviation between the accounting treatment and the GST law. Then next clause would deal with import of services by a person from a related person or from any of his other establishments outside India in the course or furtherance of business. This is very important. Let us say a holding company provides consulting service free to its subsidiary. It would trigger clause 4, and the recipient has to pay tax under reverse charge, although the holding company does not charge for it. Now, other establishment may also include a foreign branch. Let us say there is a company, software company in Bangalore. They have a foreign branch, let us say in South Africa. Now, any service which is given by the foreign branch to the head office would be subjected to tax, although there is no consideration. Valuation is a separate aspect. But the issue may arise. Let us say the foreign branch gives services to the head office outside India. Let us say the foreign branch provides software services for the head office customers outside India. Will it be subjected to tax? Because GST applies to the territory of India. Can you subject this transaction to tax? These are issues which were there in the service tax law. Matter is now pending in the Supreme Court. This would arise even in the context of GST law. So here this deemed supply under Schedule 1, we have to be very careful in respect of transactions between related person or foreign establishments. Now let us look at transactions, further provisions under 7.1a. Can you come back to 7.1.7, Arjunan? I was telling you about this amendment 1a. If some activities or transactions are already covered under 7.1, then the classification happens as per Schedule 2. So the criteria which you have to remember is to call something as supply and to apply the provisions of Schedule 2, it should have already passed the test of supply under 7.1. If it doesn't, then the question of looking at Schedule 2 does not arise at all. Now, before looking at Schedule 2, we would also look at Schedule 3, because 7.2 says certain activities which are specified in Schedule 3 would be treated neither as supply of goods nor supply of services. So we will look at some of those entries and understand how the law says that certain supply of goods or services are neither supply of service nor goods. And then we'll go to Schedule 2 to understand it better. If you look at Schedule 3, the first entry there says activities or transactions which shall be treated neither as supply of goods nor as supply of services. Services by an employee to the employer in the course of in relation to his employment is the first clause. Please observe carefully. It says service given by an employee to employer is not covered. What about the service given by employer to employee? That is not covered by this clause, and therefore if the employer gives some services to the employee, it would be subjected to tax. So this clause should be read along with Schedule 1 where we were looking at some of the transactions relating to employer-employee, because related person definition would also include employer-employee. They are treated as related person, and the proviso which we saw, it specified 50,000 as the upper limit. So you have to be clear about the terms of contract. The employee contract would be important. So wherever it is covered by a particular employee contract, you can say one applies, otherwise it would be subjected to tax. Now look at class 2. Going back to class 1, there are some issues which have cropped up. For example, I have a canteen facility. Canteen is run by someone else, but part of the cost is also recovered from my employees. Does it result in a supply under Schedule 1? Schedule 1 is the question. Now, let us say you are able to bring that within the ambit of Schedule 1 and say that this is a part of my employee contract, and therefore I am supposed to provide. In some factories, it is mandatory under factory law. So therefore, this is for whatever service they provide. I also remember reading, I think in Bima's case, that the Telangana High Court had rendered a judgment saying that the supply of food is a part of the employee contract. I think Justice Ram Subramanian's judgment. Will it be useful in the context of GST also? Is an issue which we have to look at. So if you are able to establish that it is, I am obligated to give that, therefore you cannot subject it to tax. Some people are looking at a different business model. I would not recover it from the employees. I would ask the employees to pay, let us say 100 rupees is charged for a meal. Employee will pay 10 rupees to the canteen fellow directly. I will pay 90 rupees to the canteen fellow. So there is no cross charge on the employees by the employer to the employee. So that is how some people are looking at it. It is another matter whether I will be eligible for ITC, etc. on the bill raised by canteen. The person who runs the canteen is another issue which we will look at it when you go to the ITC provisions. Now, Schedule 3, Clause 2 refers to services by any court or tribunal which is established under any law for the time being in force. Court fee is paid when you file a writ petition or appeal. File a case, court gives you service. In the tribunal also, you are supposed to file miscellaneous application fees, appeal filing fees. That is kept outside the ambit of tax. But for this, probably they would say that it is in the nature of government service, therefore reverse charge would apply unless it is exempted. Now, Clause 3A deals with the functions of MLA, MP, Panchayat member, etc. That is neither a service nor supply of goods. Clause 3B talks about duties performed by a person holding a constitutional post. For example, Chief Election Commissioner, a judge of a high court. So any duty performed by them, GST council member, would also be neither service nor goods. Then duties performed by a chairperson or member or burial, crematorium, mortuary, including transportation of the deceased. Probably they want the person to die in peace without bothering about taxes. So any services relating to funeral, etc., would not be subjected to tax because it is not service or it is not goods. Sale of land and subject to clause B of paragraph 5 of schedule 2, sale of building. Now you would look at this expression. You will also remember the discussion we had on immovable property. It is possible for the department to say that only sale of land transaction is outside the purview of GST law. All other things are services, even if it is relating to immovable property. And similarly, 5B, we knew this entry even in the context of service tax. Before the completion certificate comes, even if it is sale of building, I take some advances from the party customer, prospective customers. They said that it is deemed to be a service in the context of earlier law, service tax. The same thing continues in GST under Schedule 2. Now look at this transaction. Can the department say that if it is not covered by Schedule 3, I am going to tax it as services, like renting of immovable property. Renting of immovable property, whether it is a service, is an issue which is pending before the Supreme Court. And recently, I think in UTV news case, the Supreme Court said that we have to await the judgment of the larger bench of the Supreme Court, which is dealing with the issue relating to taxability of mining rights, whether the royalty which is paid for getting mining rights is in the nature of a levy which is before the larger bench. There was a conflict of between two benches, and therefore matter was referred to a larger bench. They said till that issue is resolved, we will not be able to deal with the issue whether renting is per se a service, because this concept of profit te pendere, which I was mentioning, is also an issue in that mining rights case. When I give rights, I'm giving rights relating to immovable property. So therefore it is immovable property is the issue. Now coming back to this clause 5, read with schedule 2. Now the issue would come, although the entry is mentioned 5B of schedule 2, which deals with completion certificate, receipt of advances before the completion certificate, etc. Now 5B is schedule 2 is reduced to classification matter. So therefore, can you still say that it is in the nature of sale of building only, and since it is because of the retrospective amendment by 2018 Act, the question of calling it as a deemed supply would not arise because it is in the nature of immovable property transaction. This issue may crop up. Of course, many people are paying tax on this transaction, but with the amendment made in 2018 with effect from 1/7/2017, this issue will open up. Now look at 6th clause. Actionable claim is defined with reference to section 3 of the transfer of property law. So you have to understand this expression with referring to the transfer of property law. I would not like to go into the interpretation of it. It basically deals with acknowledgement of debt, excluding certain types of transaction like mortgage, etc. Since the law says in clause 6, actionable claim except lottery, betting, gambling. That means lottery, betting, gambling alone is subjected to GST. All other actionable claims, they say, it is neither supply of goods nor services. So we need not bother about it. To understand the background of lottery, you see some of the judgments in the context of service tax. Sikkim lottery, that Martin lottery's case, and certain other judgments where the levy itself was challenged can be looked at. Sunrise Associates and Andraj case can be referred to understand what is the nature of lottery, is it an actionable claim, etc. Now, clause 7 would deal with supply of goods from a place in the non-taxable territory to another place in the non-taxable territory without such goods entering into India. This is popularly known as merchant trading. And if you look at the clause 7, it was not there originally in the statute book. They introduced it by the 2018 amendment. And merchant trading, the goods does not enter India at all. My goods are lying in Singapore. I sell it to a party in Germany. Is it liable to GST was the issue. Now they specifically say that the type of transaction is neither supply of goods nor supply of services. So I would say that this is only a clarificatory amendment, though the department would try to argue that this is only prospective. Look at clause 8. Supply of warehouse goods to any person before the clearance for home consumption is treated as neither supply of goods nor services. Now, similarly, high sea sales are also kept outside the ambit of supply. So these are the various clauses which you find in the context of GST law, which deal with the transactions relating to which are not treated as supply of goods or services. Now, with this background, we can look at some of the entries in Schedule 2 so that we will understand what is covered by Schedule 2 and how the supply has to be interpreted in the light of the 2018 amendment. Now, Schedule 2, Arjunan, can you please open Schedule 2, please? Schedule 2 of the GST law is now linked to 7(1)(a). And if you look at the entries there, it either deems something as goods or deems something as services. So the first step is to go and understand whether the particular activity or transaction is actually in the nature of goods or services, whether it is supply of goods or services or both as per 7(1). And then you go on to classify it as either supply of goods or services. As we go on with the various clauses, I would draw your attention to certain things which according to me are in conflict with the Constitution. The first clause there says transfer of title in goods is supply of goods. For example, sale. Transfer of right in goods or undivided share in goods without the transfer of title. I give the right to use. That is treated as the nature of services. Now, transfer of title in goods under an agreement which stipulates that the property in goods shall pass at a future point of time is treated as supply of goods. For example, you can look at the goods sold on sale or return basis, or where there is an agreement to sell. Land and building, second clause we have already dealt with, so I would not go into that again. Clause 3 deals with any treatment or process which is applied to another person's good is a supply of service. Basically, you can look at job work transaction in this context. Transfer of clause 4 deals with transfer of business asset. Now, this is an important clause. They say that where goods forming part of the asset, I'll just summarize it for you. There are some assets forming part of the business which are disposed of, but this has to be contrasted with Schedule 1, Clause 1, which says that permanent transfer or disposal of business asset on which ITC has been taken. There may be some assets on which I have not taken ITC. So those type of transactions may be covered under 4A if I dispose it off. Then clause B, I would also draw your attention to one important amendment which happened when they introduced the 2020 Act. There was some amendment which was brought to this. I'll just quickly go to that, although it is not being displayed for you. I'll just draw your attention to one amendment which came to the schedule. What has happened is this expression whether or not for a consideration, which appears in clause 4, has been removed from the statute book. That is a retrospective amendment from 1st day of July 2017. The reason is if it is transfer of asset under, because they say schedule schedule 2 is linked to subsection 1A, which in turn says 7.1, which talks about sale or supply or transfer for a consideration. So therefore they find that there is a conflict between this entry and what is said in 7.1, and therefore this without consideration, with or without consideration is removed. So if it is for a consideration, even if I have not taken ITC, I can say that it would be in the nature of a transfer, and it would be considered as supply of goods. This clause 4B talks of a situation where the goods held for the purpose of business are put to private use or used or made available to any person for use for purpose other than business. For example, I'll give an example for this. You have an office car. Let us say it is accounted as business asset. Suppose I put it as business for private use also. I go to a mall, I go to drop my children. Is it in the nature of a deemed supply? Now, fortunately, there is no consideration charge, and therefore you can say that although I put it to personal use, this is merely an entry for classification. Therefore, it cannot be subjected to tax. But suppose you give the car to your wife for use, then they may try to bring it within that schedule 1 and say that there is a transaction between related persons and therefore subjected to tax. So I'm just giving an example of how this can be used. Now clause C talks about goods which form part of the business asset, which is sold or supplied in the course of furtherance of business. Before he ceases to be a taxable person, it will be treated as supply. However, there are exceptions to that. Suppose there is something called a slump sale, where I transfer all the assets, all the goods, all the assets and liabilities to someone. Business itself is sold. That would not be covered. That would not be a case of transfer of assets or any goods forming part of business asset which is ceased to be used by him. That is an exception which is carved out. What is slump sale? Lot of case law development in the context of income tax and VAT. There are interesting cases. The courts, in one case, what happened, all the assets and liabilities are transferred except goodwill. So the department would take a view that since all the assets are not transferred, it would not be in the nature of slump sale. The court took a different view. They said that although this goodwill is not transferred, still it is in the nature of slump sale. Of course, you will also find some conflicting decisions on this aspect. So those decisions can be looked at on this aspect. Now look at clause 5, which basically deals with supply of services, the heading. The following shall be treated as supply of services, renting of immovable property. Now the basic question is it in the nature of supply? We have to wait for that larger bench of the Supreme Court. Then 5B, you also find reference to 5B in Schedule 3. Because 5B says sale of land and sale of building except what is mentioned in 5B. So 5B, the building is intended for sale, but I have collected some consideration before the completion certificate. Now, with the amendment introduced in 2018, can we take a view that earlier you called it as declared service under service tax law, and in GST when you introduced this 5B was a deemed supply. Now it is only for classification. Therefore, you cannot tax something which is not in the nature of supply under 7.1. That issue again crops up here. Clause C talks about enjoyment, temporary transfer or permitting use or enjoyment of intellectual property rights like patents, design, technical know-how, etc. Now clause D refers to development, design, upgradation of IT software. It is deemed to be supply of services. But you also remember the judgment of TCS in the context of sales tax. For the first time, the Supreme Court would discuss about software when it attains the status of goods. And the argument before the court, it was argued by Mr. Soli Sarabji. It said that it is intangible in nature, therefore it cannot be goods. That was negated. And they said that the moment you put it on some media, it attains the status of goods. Agreeing to obligation to refrain from an act or to tolerate an act or situation or to do an act. This was there even in the service tax law. Lot of litigation on this. What is this agreeing to obligation? I'll give few examples. Liquidated damages. Is it liable to GST because of this particular entry? Notice period pay, recovery, notice period recovery. Is it covered by this clause? Now, one argument which can be advanced here is only when I tolerate an act, I can be included here. When I claim compensation, I am not actually tolerating the act. So therefore, you cannot invoke the provisions of clause C. In fact, there was one matter where we took this view before the departmental authority. The proceedings are dropped. I also remember reading some decision in service tax context on this aspect. Notice period recovery, whether it is liable to tax or not. So basically it is intended to cover a situation. Let us say there's a competitor and I tell him that I want to sell exclusively in this particular territory, let us say Karnataka. So I'll pay you every month a certain sum of money. So you should not sell your goods here, or you should not operate. That is a clear case where you can say you are covered under clause C. But it cannot be extended to such an extent to cover everything under the sun. But incidentally, when it comes to government contracts, they are given some exemption in respect of these liquidated damages. As someone asked me in the beginning, first of all, you should decide whether it is a supply as defined in 7. Then only you can look at the entry in the schedule 2. Now let us look at clause F, which deals with transfer of right to use any goods for cash, deferred payment, etc. It is deemed to be services. Right to use goods and supply of tangible goods, two conflicting entries in the service tax law and the VAT law. So we remember all those old case laws, the Rashtriya Ispat case, one of the leading judgments. So what they were looking at was there a transfer of effective control and possession? Now in GST context, those issues may not crop up because the levy is under one enactment, unlike the past where VAT was there, even service tax was sought to be imposed. Now clause 6 says works contract would be deemed to be in the nature of service. What is works contract is defined in section 2119, and you should read that in the context of the definition which is provided in the Act. You have to set aside all your imagination or definition which was there in the old law, VAT law or service tax law, which talked about works contract. If you look at works contract in the old context, it would be related to goods or goods, or it may be relating to immovable property also. But here, under the GST law, the definition is restricted, unlike the old definition which you had, and it would specifically deal with the activities of building, construction, installation, etc., which is relating to immovable property. You may ask a question, what if I do some installation or something repair, etc., relating to goods, because it involves both goods and services. For that, there is one more concept of composite supply or mixed supply, which I would deal with in the next slides. So here, works contract is treated as supply of services. Please recall the discussion in the first session. 366(29)(a) regards works contract as a deemed sale. Constitution says it is sale, whereas service tax GST law says it is in the nature of service. So this, I think there are some petitions which are pending in the Karnataka High Court on this aspect, where there is a differential treatment under the Constitution and the GST enactment. Now you also see clause 6b. It says basically service relating to supply of food or any other article for human consumption or drink is deemed to be in the nature of service. Again, go back to 366(29)(a). The 1982 amendment says that it is in the nature of goods, sale. So there is a conflict there also. There is one judgment of Supreme Court in Damodar Swami Naidu's case, where the Supreme Court said, because of this constitutional amendment, there is an element of service that is also treated as sale only, deemed sale for the purpose of VAT. I remember there were some judgments of the Kerala High Court and Bombay High Court in the context of service tax. Before the Kerala High Court, a view was taken that service tax cannot be imposed because it is a deemed sale, and that was upheld by the Kerala High Court. Whereas the Bombay High Court did not agree with that proposition. I think the matters are now pending before the Supreme Court. Then clause 7 would deal with supply of goods, and in the context of unincorporated association or body of persons to a member thereof for cash, deferred payment, or all valuable consideration, they say it is deemed to be supply of goods. Now I would draw your attention to 366(29)(a), where there is a similar entry relating to unincorporated association or body of persons, which treats it as sale only, deemed sale. But you look at the latest judgment of the Calcutta Club decided by the Honorable Supreme Court. The Supreme Court would say that even after the constitutional amendment, it is possible to take a view that the mutuality principle is not overcome, and therefore the liability to under VAT, because that judgment dealt with both VAT and service tax, and they said that it is possible to take a view that VAT and service tax is not attracted. Now the question is whether those judgment could be applied in the context of GST also. Well, that is something which the concerned party should take a call. For example, you have so many residential welfare associations. Can they stop paying tax, saying that mutuality principle applies, therefore we are not liable to tax? It would involve a lot of litigation. You imagine this judgment relating to VAT has taken so many decades, and even service tax was introduced on club or association long back, and it has taken several years for the issue to get resolved. So is it possible to take an aggressive stand? Probably you can look at paying it under protest if someone challenges the levy, and it can be challenged only before the court of law by filing a writ petition. Now these are the schedules which are there in the GST law. Now I would go back to my slides. I would request Arjunan to open the slide. We can go to slide number 48. Basically deals with the customs duty. I have already told you that customs duty and IGST go together now. In the sense that IGST would be levied on import of goods at the same point of time when customs is imposed, and valuation would also be as per the customs law. Now, one issue may crop up. Import of goods attract customs duty irrespective of whether there is a consideration or not. But IGST, which is basically a GST law, can you say that you can impose IGST on a transaction even if there is no consideration? I can understand that if the import is made from related person, there is a possibility to tax. Or if it is between a distinct person, there is a possibility to tax. But if it is from someone, suppose someone gives, a customer says, you use this machinery for production and supply me the goods. The goods which I export would not be subjected to tax. It is zero rated supply. But when the machinery is sent to me by the customer, I have to pay customs duty, because customs duty is not dependent on receipt of consideration. Whereas IGST is linked to supply. So there seems to be some lacunae in the law on this aspect. which probably the courts have to resolve in future in appropriate case. Now let us go to the concept of composite and mixed supply. I would rather explain those issues with respect to by giving some examples. I would draw your attention to one judgment of the Supreme Court in Nokia's case. The facts were like this. Nokia would sell their mobile phone, and in the box or the container, it would also contain one earphone and a charger. In fact, any mobile which you purchase, you will find you place an order for mobile, you will also get this charger and earphone, etc. The question which came up before the court was whether mobile charger would be subjected to a higher rate. Mobiles were subjected to a lower rate, but chargers were subjected to a higher rate. And they imposed differential tax. This issue came up across the country, many VAT legislations. The Punjab Haryana High Court said that charger is a part of the mobile, therefore whatever rate applies to the mobile, same thing will apply. That was negated by the Supreme Court, of course, because of some admissions made by the party. And Supreme Court said mobile charges is a separate item, charge higher tax. Now apply this scenario in GST context. Will I charge more tax for charger? That is where the concept of composite supply resolves that issue. How do they resolve it? They define composite supply, and they also define one more expression called principal supply. What is principal supply? I supply something together. There is something which is the predominant element. For example, in this mobile phone set, which I give it to the customer, the predominant element is mobile phone only. Other things are only ancillary or incidental, like charger, earphone. So they say whatever rate applies to the principal, apply it to the ancillary item also. So they resolve that issue which cropped up in the VAT context. Looking at one more example, I supply goods. I also arrange for transportation. Should I charge a separate rate? Because transportation is a service, whereas the principal supply here is goods. They say you treat everything as a composite supply and adopt the rate which is there for the principal supply. So this is a sort of tiebreaker rule. But this is not as easy as it seems. There may be situations where it is difficult to determine which is the predominant element. For example, let us say there is, assume for a moment that there is a huge power plant which is put up. There is this supply of goods, there is also supply of services, construction activity. How do I deal with it? Now I was also referring to some of those Schedule 2 entries. They say works contract, construction, installation, etc. relating to an immovable property. They say it is supply of services. That is how the law resolves it. So how do you decide what is principal, what is predominant element? This depends on the facts. Now I'll give one more example of mixed supply. Mixed supply is a case where two goods or two supplies go together. It may be goods or services, where I charge a single price. For example, I sell cooker, but I also have a scheme. Cooker and tawa, I sell it to you for one single price. Now, if you take cooker rate, it may be different. Tawa rate may be different. Assume, for example sake, that the tawa rate, assume it is 28%, cooker is 12%. Now, what happens? The law says this is not naturally bundled. Naturally bundled means it should be in the ordinary course of business. That is how it is sold. For example, mobile charger along with your mobile phone. Whereas tawa and your pressure cooker is unconnected. It may be used for cooking, that is another matter, but that is not sold in the ordinary course of business in that manner. It is some special scheme which I conceive. So how does the law deal with it? They say you apply the rate whichever is higher. Let us say tawa is 28%. For the entire supply, you apply 28%. So therefore, we should be careful in evolving marketing schemes. Remember Diwali, you get a gift, you buy something to give it to your customers. So you will say, I want dry fruit, badam, I want cashew nut, I want chocolate, the same box. This is mixed supply. Assume for a moment the rate of one of those items is more, then the entire value would suffer that rate. So this is the concept of mixed supply. Nothing prevents the customer, nothing prevents the assessee in having two rates, two prices for two supplies. Only when you supply something together for a single price, the concept of mixed supply becomes relevant. I can always, for example, now we have this COVID situation, and sometimes you order for groceries and they bring it in one carton, give it to you. That is not a mixed supply, because there are individual rates for those items and a bill is raised for that. So that is not covered under mixed supply. Now let us look at some of the issues. I think major part of it is already discussed. I would raise some more issues and then we'll take up few questions. It is already 1 o'clock. Maybe for another 5-10 minutes, I'll deal with these issues and then take questions. If you look at some of the issues which have cropped up, the first issue which I place before you is how inclusive is the inclusive clause in 7.1? Is it wide enough to say anything and everything is in the nature of supply? If you see those examples which are given there, it is quite exhaustive. Although they say it is such as, it covers almost all forms of supply which you can think of. And of course, I also gave that example of immovable property, whether it is covered or not, particularly in the light of 2018 amendment. I'm sorry that I'm emphasizing on that, because that is one of the major issues which has cropped up in GST law, and which has attracted the thinking of lawyers, judges, and clients alike. So come to slide number 51. Services performed, provided, received, and consumed outside India, whether it is leviable to tax. Now, I was giving you an example in the context of Schedule 1. If you look at, I would draw your attention to few decisions of the tribunal which are reported in Excus and TAOL in the context of service tax law. There is a case of Intas Pharmaceuticals decided, I think, by the Ahmedabad bench of the Sustat. Then there is one KPIT Cummins decision where I assisted my senior Bombay bench. Then one Infosys Technologies case, Infosys Limited, Bangalore bench. There also I had assisted my senior before the adjudicating authorities. So the proposition laid, there are other decisions also. For example, Torrent Pharmaceuticals, Mahindra's case, where the issue came up before the court was, can you extend service tax law to even territories outside India, foreign territories? For example, I would avail some services out, my employee goes abroad to customer's place. He avails foreign services, which is ultimately booked here. Can it be subjected to tax? I engage a foreign subsidiary to render services to my customers. Can you subject it to tax? Because service is performed, consumed, provided, received outside India. So you read those decisions. They say that they also look at one Supreme Court judgment in All India Federation of Tax Practitioners and say that what is the nature of service tax? It is a destination-based consumption tax. The same principle applies to GST also. So can you extend the law to foreign destinations and say I will tax it? This issue cropped up in the context of place of supply of services. You read one judgment of the Delhi High Court. I think it was tour operators case. Association challenged it, where they explained this controversy. I think now it has gone to the Supreme Court. In the place of provision of services related provisions in the Act, which is there in the IGST law, you would find, strangely, that they want to tax something happening outside India just because the service provider and the service recipient are from India. So you will hear more about this with examples when you go and look at the place of supply provisions. Just because the location of the supplier and recipient is in India, they ignore the place of performance. This issue came up even in the context of service tax law. For example, I have an aircraft which has gone and landed in Singapore. There is some technical snag. I have a maintenance contract with someone who is in India. He goes and repairs the aircraft. They say location of service provider and recipient is in India. Therefore, it is liable to tax. This issue was there in service tax also. So some of the provisions in the service tax law, which were part of the rules, were challenged before the court. Now, ironically, those provisions have become part of the Act itself. But still, it is open to challenge on the ground that you are trying to extend the operation of the law and trying to tax some transactions happening outside India. Then works contract restaurant activity, Constitution says it is deemed sale, whereas our GST law Schedule 2 says it is in the nature of service. So there is a conflict. Head office and branch transactions, whether it is taxable or not. If it is different as foreign establishment, then I was drawing your attention to Schedule 1, which even though there is no consideration, it is deemed to be a service. But what about transactions within the country between head office and branch? Earlier, again, you may have to go back to those decisions in KPIT, Cummins, Mahindra, and Infosys. Read those decisions, you will understand the controversy. Now, in GST law, they say that they are distinct persons. Therefore, head office branch transactions would be liable to tax. That does not mean that you should extend it to such an extent that you would cross charge for expenses, you would cross charge for the salaries. Can you say that the employee of a branch is not an employee of the head office? So he is an employee of the company. So he is an employee of the branch and employee of the head office at the same time. So you read the advance ruling in the case of Columbia Asia case, you will understand what I am talking about. It goes against the basic principle of one cannot do business with oneself. Now, these are some of the issues which I brought it up for discussion, including many other issues which we discussed. So now we have some time, or 10 or 15 minutes, to look at questions. You can send your questions to Arjunan, and wherever possible, I will try to address it. Suppose it requires a lot of discussion or a lot of study, then I would request him to pass it on to the panel which is going to address you on the last day. There's a special session arranged where many issues would be taken up. So wherever I'm not able to address an issue immediately, I would probably request Arjunan to pass it on to the panel. Yes, Arjunan. Do we have questions? Hello?
Arjun should see whether you got any questions.
Yeah, just to 1 minute, sir. We'll just get the question.
I'll wait. Thank you.
Nice session, Naveen. Very nice,
Thank you,
well paced.
Thank you.
Let's hope
I didn't know that you are there.
I was there. For me, it's always some, I'll do something else also, but I'll be there like that.
Okay.
I have a session in the afternoon.
Oh, I see. Okay.
Webinar series. One more webinar series we are having. 4 to 6 or something. There's a session.
Okay. I think this lockdown is a blessing in one way, in the sense we are looking at different ways of using technology. We were not very comfortable when we were looking at this camera and speaking. I think necessity is the mother of invention, and as we go on, probably we will also try to develop some acting skills, how to face camera and how to make it more presentable. So these things we should learn. And now we are looking at addressing the courts using video conference, so that physical presence may not be required. Sitting here, I can argue before Supreme Court.
Yes, yes.
That is the way forward, and social distancing is the norm, at least for the next 1 year.
Okay.
True. This thing, environment also has become very good now. You look at the skies, everything is improving from that point of view. Yes, Arjun, please go ahead.
Arjun has some technical, sir. This is I'm continuing with this. I'm asking questions which have been asked by the participants.
Yes.
A few questions can be addressed now. There are a lot of questions. Sir, one question is that, dear sir, can you please elaborate the meaning of levy contrast with exemption?
I think this question was already asked in the first.
Just go to the next one.
With reference to PK, I think you are repeating.
No.
2 questions he had already asked.
I'll go to the next one then.
No, he had already asked for 2 questions.
What are your views on levy of GST on liquidated damages?
Okay, this I already explained.
Explained in the.
There is an entry.
Can you send that to mail to Naveen? If you got a list of questions, Rajendra.
Yes, sir. I have the list of questions. I can send it to.
Can you send it to his mail?
Yes, I can just send it.
Email ID.
Yes, sir.
Yeah. In the meantime, you ask the question, then you send it so that he can see in his laptop and answer much faster. Because we have only 15 minutes.
Okay, sir.
Yeah. So as far as liquidated damages, liquidated damages are concerned, if it is government contract, it is exempted. But if it comes to private parties, there are certain advance rulings also on that. They say that it is liable to tax. There is one decision of the larger bench. I think it was argued by Mr. Aravind Datar, and the instructing counsel was Mr. Gururaj. In a case of United Telecom, if I remember the case, where they beautifully explain the meaning of liquidated damages. There, the argument taken by the council was this liquidated damages are a part of value itself. Under what circumstances it becomes a part of the value? That is, you would read it in the context of central excise law. So as of now, the understanding is that when I charge liquidated damages, if it is government contracts, it is not liable because of the exemption. If it is private contract, there is delay in payment. I charge him, there is a delay in supply. I ask for damages. Then the understanding is that because of that entry, it would be subjected to tax.
Okay. I hope the question is answered in a detailed way. I'll take up the next question. Do reimbursement of expenses from the client is also covered under the scope of supply?
Of course, this is an issue in the context of valuation. I'll just add one line and finish it. You'll hear about it later. Reimbursement, there is a concept of pure agent. If you are able to fulfill that, I would not deal with the definition of pure agent. If you fulfill that criteria, there is no need to tax.
Okay. We'll go to the next question.
Yeah.
Does restaurant services comes under composite supply? What is the GST rate on these services?
Restaurant service comes under composite supply.
Yes.
I think rate is it 2%? Hello.
Yes, sir. I think it is 2.5, 2.55%. 2.5 CGST and 2.5.
2.5. Yes. So
Yes.
5%.
5%. The next question. Drawing from your.
What is the difference between title in goods and title of goods?
I couldn't hear you, sir.
Yes, sir. I'll take up the next question.
Hello,
Yeah.
Rajendra. Can you put the speaker and show the. Hello.
Yes, please.
Send a mail, no. At least you send the next question.
The next question I'll take, sir.
Naveen, you can see your laptop only and then answer from there rather than.
No, it has not yet
too
come.
much echo. Okay.
Hello, Rajendra.
Yes, sir. Yes.
You can ask the question, what is the difference between title in goods and title of goods?
You are audible now. I think Naveen sir got this. He's asking what is the difference between title in goods and title of goods?
Where do you find it in GST law? Title in goods, I think in one place in Schedule 2, they talk about title in goods. But title of goods, where do you find it? Title in goods basically refers to ownership. But I don't think a title of goods is used. Is this question in any particular context? Or is it bad English? Arjun?
Okay, sir. I'll mail that question and we'll get it clarified through mail only, sir. The title
Yes.
in title of goods. We'll go to the next one. Drawing from your example of mixed supply, if a company evolves a scheme for buying 5 kg of atta, you will get a chocolate free. So with a higher
You
rate
will
of
get a chocolate
free.
free.
Yeah.
Okay.
So with the higher rate of chocolate, will the higher rate of chocolate apply to the atta price?
No, there is mixed supply. You are actually supplying goods together for a single price. If I am giving something free, then you may have issues under ITC. That is the issue which we have now. Read with Schedule 1, which talks about permanent transfer of business asset, where you have taken ITC. That is not a case of mixed supply.
Okay, sir.
Mixed supply is there, they supply in conjunction for a single price. It is not naturally bundled.
Okay, I think the answer is sufficient. The question is sufficiently answered. I'll take up the next question.
Yes. Yes.
Employee is employee to the company and not to the branch. Then how
Yes.
services to branch can cross charged?
That is the problem which cropped up in the Columbia Asia case, where the advanced ruling authority made a distinction saying that you are an employee of a branch and not employee of the head office. I think that type of argument by the department or the advanced ruling authority flies in the face of the general understanding. Because I receive a contract, employment contract from the company. So when I say company, it is like saying that your hand is different from your body. So when I say I'm an employee of a particular company, I am employee of all the branches. Tomorrow they'll ask, go and do some work and come back. So you cannot stretch it to that extent. So I would say that the Columbia Asia case has stretched this Schedule 1 to an extent where it is not required. And that is why it has been challenged before the High Court. Matter is still pending, but I think this has triggered panic reaction across the board. And people have, of course, have taken a conservative view and cross-charge for employee costs, expenses, etc. Since credit is available at the other place, I don't see much of a problem except for cash flow issue. Wherever credit is not available, for example, if it is hit by exempted supplies on Rule 42, 43, then there may be a problem.
Okay, sir.
That is a wrong
Naveen,
ruling. Yes, sir.
there was one tribunal judgment in service tax, na, or some other about 4 or 5 months back on the same matter. No?
Recent one I have not seen, but there is one decision which we were using in the context of service tax. I think it must be Araco Corporation's case or Rolls-Royce, where this, whether at all there can be a service between branches was there. And you look at the old income tax decision, one cannot do business with oneself. Sir Kikabai Premchand's case, a celebrated decision. Branch is only an extended arm. Can you bypass that principle of law and say that there is a supply for everything and anything? I can understand. Let us say a chartered accountant has a branch in two places. Head office is in Bombay. Whenever an opinion is received at one state, let us say the principal partner reviews it. There can be a case made out under Schedule 1. But that does not mean that you can extend it to any length and say that I have to cross-charge for everything. Of course, that is an aggressive view, since you will go against the advanced ruling and the general understanding of the department.
Okay, sir. Thank you, sir. I'll go for the next question.
Yes.
Further, if I have availed ITC on some business assets on which ITC was blocked by mistake, then
ITC is
further, if I have
what happened?
availed ITC on some business asset on which ITC was blocked by mistake, then
Blocked by mistake. Okay.
will
Okay.
it trigger a supply under entry 1 of schedule 1?
No, schedule 1 applies only if I transfer that business asset. It says permanent transfer of business asset. But here you are saying ITC is blocked, is it?
Yeah, they are saying by mistake they have blocked.
By mistake blocked means there may be some accounting malfunction or technical problem in the GSTN portal or whatever. That does not make it a supply. Supply should be exclusively covered by schedule 1, that clause 1.
Okay, sir.
There should be a transfer, permanent transfer.
Okay, sir. Then we have one more question.
Yes.
If CA in practice buys and sells gold as investment, can it be said that in course of business, considering the wide definition of business, and treat it as supply?
In fact, I had thought about some of these examples in the morning, but somehow it got missed out. Let us say a chartered accountant. Chartered accountant is liable to tax under forward charge because advocates come under reverse charge. Now the question is, can you say anything and everything can be called as business? I will give one example. Every CA buys a newspaper at home. Okay. And after 2 or 3 months, you go and sell that newspaper, whatever you get. In fact, you don't even realize it happens without your knowledge most of the time. Can you say that I am liable to pay tax on that newspaper which has been sold because I am doing CA activity? Similarly, I think one example was given that press release also. A lady giving some gold to a goldsmith. I have gold jewelry. Can you say that when I go and give it to the goldsmith, I'm selling that and therefore it is a taxable supply? So that is where the definition of business comes to the fore. Am I engaged in that business should be the question. I have a car, I dispose of the car and buy a new one. Does it mean that I'm engaged in the business of selling cars? What is my activity has to be kept in mind. That is how I would understand it.
That means to say, like, we have to analyze case-to-case basis.
Yes.
When we have the main business and the other activities related.
Correct.
Okay. Can we take up one more question, sir? 1 or 2 questions, and
yes.
If an employee resigns without serving the notice period, is the employee liable to pay GST on the payment made to the employer for not serving the notice period? Payment made as
I think I discussed it, but I will repeat in a different manner.
Okay.
When I recover those charges, actually I am not tolerating. So therefore the clause is not attracted. And this is the argument which I advanced in one of the proceedings, and the proceedings were adopted under service tax law. I think there was also a recent decision accepting this proposition in the context of service tax law. Some tribunal decision I have seen, although I don't remember the citation.
Okay,
you can use that in the context of GST.
Okay, sir. Okay. We'll move on to the next question.
Yes.
If a person is purchasing 6 products.
One more thing I want to add there.
Please.
When I actually, what happens in this case is there are some decisions in the context of labor law It says that a person serving the notice period is entitled to salary. Okay.
Okay.
So what is actually happening here is I am actually paying salary, but I am deducting something out of that salary. So therefore, I am not receiving anything called recovery of some charges. This is also one more way of looking at it.
Okay,
So
sir.
the law requires me to pay in salary. I don't pay salary to some extent. So it is a deduction of salary.
That
And
means
therefore, there is no separate situation for tolerating act and all. In fact, I am not tolerating. This is one more argument which we advanced in that case.
okay, sir.
And we succeeded to.
That means
Yes,
to
sir.
say that
Naveen,
Yes, sir.
Naveen, you can take a couple,
Yes.
10 minutes more because we lost in the starting.
No, I didn't get it. What did we lose?
You can take another 10 minutes of question answer.
Fine, fine. I'm available. No problem.
okay, sir. We'll
Yes, sir.
take
Next.
another question. If a person is purchasing 6 products, A worth of 10,000, he purchases 6 numbers with 6 different inputs, which is traveling in the same vehicle from one state to another. Is e-way bill necessary?
This I leave it to the person who deals with e-way bill procedure.
E-way bill
It
procedure.
is
Yes.
premature to answer that.
We will take up that at that time only.
You mark it and keep
Yes.
it for them.
Okay, sir. Next question. If I buy a car for the purpose of business, can the tax amount into the business? If so, can you briefly explain? This is what we just discussed, I think. No,
Yes.
this is different. If I buy a car for purpose of business, can the tax amount be taken into the business?
Are they talking about ITC?
Probably the question framing is not clear here. Maybe
I
they're
think
taking
talking about ITC.
Yes.
ITC, there are restrictions
Restriction
that
here.
I think we can deal with later.
When
ITC restrictions. This was there in service tax also. Except I am into selling of cars or driving school, etc.
Yes, sir. So we will take up the next question. In case of
Yes.
differences between GST council members, between them, will there be a vote or a veto?
There is a voting. You look at Article 279A, they tell how the voting happens. Till now, we have not seen that type of situation. And of course, if everything fails, I think they give this center more power, extra power under 279A. That is there in 279A. You can read it is there in my PPT also.
Okay, we have one more question, few more questions. I'm taking another one. In the sales tax
Yes.
E1, E2 transactions, benefit of no tax was denied on the ground that same is predetermined transaction. Whether the same logic can be extended in high C sales if it is predetermined.
No, what do they want? What is the question?
In a sales tax law, E1, E2 transactions, benefit of no tax was denied on the ground that the same is predetermined transaction. Whether the same logic can be extended in high C sales if it is predetermined.
See, all those old concepts are no longer relevant. When it comes to high C sale, you should look at Schedule 3. And they say it is neither supply of goods or services. That is what we should concentrate. We should not bring our old understanding of the law and try to apply those principles out of context. That even E2 and all is not relevant now. So why should you borrow that concept here? You have to see Schedule 3 and decide.
Okay, sir. Then related to that, only few questions are there, so that I think better to deal with the old law and this one. So I have one more
Yes.
question. I'll just go and questions are coming now.
Hmm.
What is business asset? Is it only those assets on which depreciation is charged?
The business asset is not defined. That is the problem. Now it is left to chance and what we perceive as business asset. Should you look at it from the perception of an accountant and say whatever I show it in the balance sheet alone is an asset, other things are not an asset. If you read the general understanding of asset, it is much wider. They don't restrict it to how you account it in the balance sheet. So that is where that usage of that expression assets, business asset, which appears in Schedule 1 and Schedule 2 will pose problems.
Okay, sir. We'll take one
It is
last.
vaguely defined. Therefore, I would go only by accounting. I would say that business asset means if I have shown it in the balance sheet, then if I dispose of, then I will look at Schedule 1. If it is written off, in fact, I was reading one judgment of the Supreme Court in the context of income tax law, a very old judgment, which I read as a student. There they would say that if I have taken one property on lease, let us say for 50 years or 60 years, I build something on the property. Then they say that building can be written off. There is no need to, you can claim it as an expenditure. There is no need to show it as an asset. You read the judgment of Madras Auto Service Private Limited. In fact, recently we were discussing with my friend Shilpi Jain in the context of this ITC, where they say on my own account, there is one own account which comes in that exclusion clause in the ITC context, section 17. So what is business asset is not clear. So I would only say that if it does not appear in the balance sheet, it is not an asset. Therefore, I would not apply Schedule 1 or Schedule 2. Yes, sir.
Okay, sir. We'll take the last question, and then any other questions which you've posted now will be addressed through mail or the last session
Okay,
of the day.
fine.
Today's last, we'll take up last question. This is what HSN to be used for composite and mixed supply or predominant supply.
See, as far as composite is concerned, once you decide that the principal supply has to be adopted, then you will go by the HSN of the principal supply. And if it is a mixed supply, it is a tiebreaker rule. They say you go by the higher rate. First, you will classify those two things, and while paying tax, you will go on the basis of the higher rate. That's all. And as far as services are concerned, there is this SAC which is used. That is also based on UN classification of services. Harmonized system we are all accustomed to in the context of customs and excise. Our customs tariff and excise tariff was aligned to HSN, which is basically harmonized system nomenclature developed by the World Custom Organization, Brussels. So that is adopted for GST purpose also.
Okay, sir.
And for services, there is classification.
Sir, other questions? I'll coordinate with you and with the participants so that it can be answered through mail and which will be through our Hiregange Academy website.
Fine.
Sir, so that we are at the end of the this today's program.
I thank Hiregange Academy and also all the participants who are there in this program, and I wish them a great learning session. Now that we are under lockdown and there is no other disturbance, I think this batch of GST course will learn more than all the previous batches.
Thank you very much, sir. And
Thank you.
Thanks,
I
Yes, sir.
I think participants, any feedback, please do send so that whatever is possible, except for internet, I think everything else we can deal with. Please give us your suggestions and we will try and see if we can do something about it. Thank you and have a wonderful day. Bye.
Thank you.
bye. Thank you all.
Bye.
Thank all participants.